Yes. Tomorrow? You said tomorrow. What are your grounds? Okay. Please bring. Admission, matter of which year? Last listed. What was the order? What was the order? When do you want? Yes, yes. Contempt of which year? It will come on its own. Why do you mention? Yes. There is no urgency in contempt. Sorry. Yes. 9. Yes. Yes, and from the other side. Yeah, yeah, the adjournment is sought for by the respondents. When do you want? After 21st. Okay. Today is after 21st of what? Why so long a day? Today is only 29th. Matter of 2023. We can accommodate you on a request made on behalf of the respondents. Matter is adjourned by 2 weeks. 2 weeks. Interim order passed earlier to continue till the next date of listing. Why are you mentioning? When was it last listed? Not a case for mentioning. Sorry. No. Yes. Thank you. Motion. Urgency is there. Okay, tomorrow is. You have received? Yes. Not an urgent matter. Don't make mentions out of turn of matters of normal nature. Sorry. Next. (23 to 32). Yes. Yes. Yes, yes. Please bring it. Give a requisition. Okay. 46, do you want to withdraw 46? 46 you don't want to withdraw. Okay. Okay, okay. You write only in 45, huh? Sri P. Hajarika, learned counsel for the petitioner, has submitted that he has instructions not to press this petition. Also heard Sri R. M. Das, learned standing counsel, Water Resource Department, and Sri N. Goswami, learned state counsel for the official respondents. Para. Writ petition is accordingly dismissed on withdrawal. In 46, you write, list this matter after a week, after 2 weeks. Why liberty? Then why are you drawing? Why are you tell us the reason why are you drawing? It cannot be for the same cause of action. Withdrawn, but the place for withdrawing with a liberty, last up, what liberty as paid for, with liberty as paid for. Okay. 45 stands vacated, huh? 45 interim order stands vacated. 46 after 2 weeks. I will also go, Mr. প্রথম আই টু যাব হ্যাঁ দুটো আছে আই তোমার 86 of 2020 2024 dismissed. Yes. Yes, Mr. Burrow. You are placing which record of which case? So accordingly, this matter. The issue is that. No, which record would you like to refer now? 1479. Okay. First, 2021 of 2021. Just a minute. Pre-3. 2021. The Lord will find that order of the repetition. Yes. Page 16. Of which one? That's why we have asked you which repetition you'd like to refer. 3637. It is just a minute. লিখি দিয়া লিখিলে এটা হেৰি পেন ৰাখিব কি বুলি কয় মাৰ্কাৰ মানে হয় নাযায় দে 3637 ভালকে লিখিব লাগে Okay, you are taking up 3637. Okay, which page? If there is something that at this stage the necessary direction be given to proceed, who cardio law takes action on the basis of the representation of the document dated 23/6/2021. Similarly, of the view of district before the consideration of the submissions of the Land Council and as consulted by all of them, this petition says disposed of at this motion stage, thereby directing the petitioner to submit address verification necessary documents to the respondent number 2, 3, and 4, upon which necessary actions shall be initiated by the respondent number 2, 3, and 4. After hearing the affected parties, including Srimati Bhansuni Impri, against which the petitioner has made specific allegation of encroachment the land of the tea estate. The said actions shall include proper demarcation of the land, the tea estate, and also for a prima facie finding in respect of the ownership of the said garden and the legality of the possessors and of the land which belongs to the garden. Needless to say, the respondents shall dispose of the representation and the action initiated thereupon expeditiously as possible after hearing of the affected party. Accordingly, this petition stands disposed of at this motion stage. Okay. Now, this action was to be taken by the KSA, therefore demarcation and all, but they could not. They didn't do it. Then what happened? The other person, which my landed senior council is representing, and the other repetition, they come up with one repetition. That was WPC 357 of 2023. Our grievance was that when she went for mutation of this alleged land, telling her the authorities were not acting upon it.
I filed a writ petition, WPC 661, 2023, raising objection that she should not be, mutation should not be done in her favor because I am the garden is my possession. Now, common order was passed by Justice Siam on 21 August 2023.
Page?
Under that order, Your Lordship,
Mhm.
kindly come to para 9.
Yes.
In view of the above, without expressing any opinion in the merits of the claim and counterclaim,
Mm.
the parties that have agreed by pleaded counsel for both the sides.
Mm.
Both these petitions are being disposed of by granting 10 weeks time from today to the respondent number 4, that is the Joint Secretary Department of Revenue KAC, before to pass appropriate orders on the application dated 22/9/2022 submitted by the petitioner in WPC number 357/23 for mutation. Before passing any order, the objection filed by the respondent A and K should also note of this make it clear that it would be open for the concerned authority to pass appropriate order on the application seeking mutation based on the materials available on records on the date of passing the order. Facilitating the above, the contesting parties are directed to cooperate with the authorities by producing all the relevant documents as may be called. With the above observation, both the petition stands disposed. Now, subsequent to this, the mutation order was passed in her unquinty, which the second petition which is pending here. Here, her mutation application was rejected. Against that order, that petition is there, which is WPC 5027, item number 2. Item number 3. Now, during this entire pendency, I have again come before this honorable court in WPC 1479.
5027. 5027.
Again, the petition 1479 was with respect to the order passed by the writ court on 27/2021 that you go for proper demarcation, acting on our representation. That has not been done. So again, I think that matter is pending till now. Now, what happened? Now this third petition which has been filed, the Lordship will kindly see that I have been continuously making representation to them. There might be a civil dispute between me and some other persons, Hanumanti proprietor, that is pending in the civil court in Alipur. There is no dispute on that. But the question is that my land which I am at, the garden in which I am in the possession, that has been systematically been encroached by the people. So I was asking that you protect my land, you protect the garden. That is the duty of the state. But on my representation, they were not acting up. So subsequently, what happened, Your Lordship? I made the last representation. Your Lordship, kindly come to page 47. Page 47 of my petition.
Yes.
This is the notification dated 26 December 2024. It reads that the authority of the Cardium Autonomous Council Tipu is pleased to allow a plot of land measuring an area of 200 biga, 0.0 lessa, covered by survey dark number 1 at village Nimot Kufar under Morjan Moza of Tipu Land Revenue Circle for establishment of Nahar Longso village on payment of allotment fee on amount of rupees 57,500 by receipt number so and so. dated 22 December 2024, subject to payment of Tausi land revenue annually. The plot of land will automatically be reverted to the council authority if it is not utilized within 1 year from the date of taking possession of the land. Joint Secretary IC Revenue, the original copy is my lord. Will kindly find it page 49.
Yes, we have seen. It's given to whom?
It has given, it has been given. What to the common people there. Copy has been marked to the PA, to the executive member for kind appraisal of the honorable executive member IC Revenue, issue, assistant revenue officer, assistant settlement officer, issue land revenue, cycle for information and necessary action. This is in reference to his data number KAC ASO TIFU allotment 514 dated 2/12/2024. The head Nahar Longso Village Karbianglong office file. Now acting on this, some people started enforcing my land. Now I made my final representation again. Again at page 44, annexure B6.
Yes.
Till date, Karbianglong authority has not complied with the honorable High Court by order dated so and so. In petition supper so and so. As a consequence to the same, the undersigned land was systematically enforcement is going on. As per the undersigned council advice, the Karbianglong council does not have the power to grant mutation of the undersigned land as the land belongs to government of Assam. So till date, your office of the revenue is misusing and misguiding the undersigned as the undersigned is running from pillar to. So you also know that with respect to my land, there is an order issued by Joint Secretary Revenue Karbianglong Autonomous Council dated 26/12/2024, where officers decided to allot a plot of land measuring an area of 100 acre of my tea garden to some villages for sum of ₹7,500 each. And in the said order, Joint Secretary says that if the said land is not being utilized within 1 year, then the land will be taken over by Karbianglong Autonomous Council. This fact scheme says that some external forces help them to take over the land from the undersigned. The situation is such that the undersigned physically going to his own land has become a threat to his life. Accordingly, I request your good office to immediately comply with the High Court order as mentioned above and immediately issue administrative order to stop illegal enforcement of the undersigned land within a period of 7 days from the date of receipt and my representative. I am sending this representative to the DC Karbianglong also in email ID. This was been sent to the email ID, my lord. Your lordship will kindly find it page 46
Yes, we have seen.
and 46A. I did not receive any response. I did not receive any response. So now what my submission is. There is also an order. They have already came before contempt also. My senior colleague has brought this matter for contempt because they were not complying with the order that commutation was not being done. And subsequently, the contempt was closed because they assured that they have taken steps with respect to mutation as claimed by petition number 3. Now, there may be some civil dispute. There may be some civil dispute, I am not denying. It is pending in the Alipur court in Kolkata. But the question here, moot question is that when there was an order passed by this High Court, by this court, that you please take care of the land, provided protection is required. Why they are failing to act on it? They are saying that it's a private dispute, civil dispute between two parties. You what? You have the power under 144. You have the power under 145 in the CRPC. Right? Stop it. Because tomorrow, for example,
Have you filed 144, 145?
see,
No. Have you filed 144, 145 proceedings? So there will be a difference between a representation and a proceeding under 145.
page 33.
33. Yes, please. This is an this is an Ajahar. Yes. You have not initiated 144, 147. That option is still available to you. If you think that miscreants are trying to occupy your land, trespass into your land.
There was order asked by the very 21.
Hmm.
What happened? How my land became so attractive was that?
The first order, Mr. Borgohai, the order of this court of 27/2021, whereby your representation was directed to be disposed of, has that been done?
Not yet. Series of representation.
Okay, okay. Yes, Mr. You're for whom? Chaudhary? Yes.
Whereby we got my application for the visit.
Yes, that was narrated.
Fact, I would tell my friends client as an adversary because I claim I am the owner of the industrial space. I am agreed by an order by which my mutation has been refused.
Yours is 505027 is your matter.
And for the original vendor,
Hmm.
there is going on in the calendar. So it's going.
Okay.
I come to my order at page number 164.
In your petition. One 160.
Yes. Problem. The people who understood. From filing an application for mutation of land measuring 2 gigas, 3 kata, 1 less of 1.16 situated in Napolitan of the border applicants claim mutation of the land. Being that her husband based from is his own personal capacity and as a president of some central forest protection NGO and arrange the fund for the purchase of both the estates and this has one company executed the sale deed with influence in favor of one later. Officials were issued to the recorded Pataholders English, Nadimitra Gupta, Chandali, Munali, Devashri Mukherjee, Mr. Varman Company Limited, and Mr. Pele Gezi, the decline of the land and also central environment and forest protection. Now appears for the recorded Pataholders Mr. Company and very the space crossing. The entry of all the central environment and forest protection is implemented by General Secretary basically in 21. And order was passed on 27/1/23 and 24 and is original commission wages partial of the case. Srimati Ampo submitted an application of seeking time to pass the original documents stating that the original documents are yet.
We have read this. Ultimately, your mutation, your prayer has been rejected. What is the date? 17th or 27th? What is this? Mr. Chaudhary, the date is 17th or 27th? There's a second. 27 or 17? No, just clarify. It looks like 2, it looks like 1 also.
27.
Yes. This is your cause of action.
Yes.
Yes.
One key company the domestic person. So company itself cannot file. Now who filed that objection? Then the record be produced. Number 1. Original, they never objected. In fact, it's a voluntary proceeding that supported us. Which I have given. Secondly, my lord, Santoy Pramane, whose signature is there in the sale deed, never lodged any complaint at no point of time. And thirdly, my lord, the joint secretary could have waited till the forensic report comes
Right? What was the earth-shattering agency? You know, we have to file a contempt petition because they were sitting over the matter. So what prompted you to file it so, arbitrarily? The record would reveal who is the gentleman who signed his application on behalf of the one day company.
That part we may be with you, but the last part, I think reasons you have said that prima facie, since objections are there, so. For mutation, will they go to the aspect of forensic? Page 175.
Earlier, my lord, there was a position, what was the stand of the one day company?
And that we have, no, that we call for the, someone is appearing for Hanuman. They are parties here. Notice is issued. You are appearing. You have not. Hanuman, who is appearing? Notice is served. We can have their views if they are not appearing adverse.
They have already taken a stand, which you have quoted in page 170.
Now today is discharged for motion because of the new matter by Mr. Borgohain. Okay. Oh, what's it? Yes, Mr. Chotia. On the first petition of Borgohain, he said that the representation which was directed to be disposed of on 27/2021 is yet to be considered and disposed of. Correct. Petitioner means Mr. Borgohain's client. Okay.
It was not transferred to Commonwealth Company, neither to the Commonwealth Company, neither to.
No, Mr. Chotia, you need not disclose what is going on at the present. If 6th is the date, you place before us the final orders. That will take care of Mr. Borgohain, but with liberty that he may be aggrieved. If 6th, it is fixed for final orders. Let it be placed before this court. You may still have a grievance. You can raise the grievance if it goes against you. Now you're on the contemplation, or you have a cause of action also that from 2021 matter is pending. Yes.
So what? Whenever we try to go, people are enforcing, cutting the bushes, cutting the tree.
6th is not too long. Today is 29th. 7 days. We'll have this matter on 9th or whenever date. Okay. We'll do it. Don't worry. Okay. Okay. Yes. Let the final orders come. If it is in your favor, you can withdraw the petition. If it is not against your favor, we will give you liberty to. Okay. Okay, this will all come in the final order. Mr. Jalan, you are for whom? You are for the NGO means for?
They have particular land.
From whom?
The executive said at one point of time the petition number 1 and 2, Predecessor and Encroachment, they were the executive member of this NGO and they were allowed to act on behalf of the NGO, not in their individual capacity. So
Okay. Another twist.
Third, I lost my husband and my 2 sons in mysterious circumstances. I can only tell. I lost my husband and 2 sons.
It is 50 years dispute. The dispute is going on for the last 50 years. More than 50 years. I lost my entire youth in this litigation. Everybody has given all the.
Who is this NGO? What is this NGO about?
There was a registered murder society under the income society. At that time,
Name of the NGO?
Central Election Courts.
What is your objective? You buy property or what? Then,
The part of that property was purchased.
The original owner, my lord, Khatak was, my lord, he died and my lord was murdered. Thereafter, my lord, garden, nobody was in the garden. Then from that, my lord, this is going on.
okay, heard,
So all these facts of.
okay, heard. Sri so and so, huh? So we're gonna, in so and so, so and so, so and so. Para. The principal grievance raised in WPC 3637 relates back to an order of this court dated 27/2021 passed in WPC 3329 of 2021, as per which a representation was supposed to be disposed of, which has not been done. Full stop. Para. The other writ petition, namely item number 3, is against an order dated 27/3/2024, whereby the prayer for mutation has been rejected. Para. So far as the first petition, first writ petition WPC 3637/2025 is concerned, comma, 3 G. J. Chutia, the Learned Standing Council, KAAC, has submitted that the matter is under active consideration and the date and the next date is fixed on 6/8/2025. Para. In view of the aforesaid development, comma, the matters are adjourned to be listed on. We'll have it on. Can we have it on 13th? 13th or 14th August? 14th August. 14th August. We'll give everybody's name. Interim order, if any, stands extended till the next day of listing. প্রথমত নাম কেটে দিল, হ্যাঁ, so and so and so and so so and so Ken Chaudhary and J Kolita for this available for the petitioners. এইখানে এটা ভিতরে থৈ দিব, এটা এটা থৈ যাচ্ছি।
In 1970. There are, it was in 1991. And in 1993, my God, document was issued in favor of the predecessor in interest of the present petitioners.
Now, what are you seeking? What is your prayer in this petition?
As per what I got, can we both go that nobody except the allotment will come in possession of the land without prior permission of the district. In my case, what happened, my lord, we have been successors of the allotments. Some of us born in the land, some of them was along with the allotments.
Okay, we issue notice at this stage. Part 3, M.A. Sheikh, Learned Counsel for the petitioners who are aggrieved by non-consideration of a representation dated 20/2/2025 by the respondent number 2. First of the petitioners claim to be the predecessors in interest, or to be the petitioners claim that their predecessors in interest have been possessing the land in question since a long period of time, and as per condition number 4 of the allotment order without the prior permission of the district commissioner, nobody can occupy the allotted land as successors. Para, let notice be issued returnable by 6 weeks. 3 N Goswami on a revenue. Revenue PR Mohanto, Miss PR Mohanto 1 N Goswami 2, 3, 4, 5. Okay, so extra copies. 22. Yes, please.
But we have dwelling houses there. This. This 22, 23 months. I have taken 3 now, this 22.
Are you taking any action? See, these are all on the basis of Tojibahi. We know the strength of Tojibahi. That you have stated it's Tojibahi.
Given, that's another issue. But we are from 1970 on the left.
Sri Sikh, the learned council prays for an interim order. Para. After hearing it is provided that interim order by submitting that there is an apprehension of eviction. Para. After hearing it is provided that no eviction can be done without following the due process of law. Okay. Okay, but they cannot, without issuing notice. If they issue notice, we cannot grant a blanket interim order on your projection. We don't even know the instructions. Let him have the instruction. He can make the returnable date for 3 weeks, 6 weeks. Returnable. Make it 4 weeks. We make it a shorter returnable date, 4 weeks. You get the instructions.
It's not a general hashtag. What your lordship pointed out without following due process of law. As we are allocation, question is separate one. So my lord, that is schedule B land. Till returnable date, let them place before your lordship.
When did your predecessor in interest pass away? When did your predecessor in interest pass away? When did they expire? When did they pass away? Then when was it? Was it recent? If you ask a question, what did you do all this time to have your name recorded? You will not have an answer. Why? You don't have an answer. See, we may also put a question which there will be no answers. So this is that much, nothing more than that. Okay, next. Yes. We have said the land in question. Okay, next. Four, 5, 6. Yes. Same persons. Different set of counsels. Huh? No, but the petitioners are the same. Petitioner wants a formidable team. Petitioner wants a formidable team. It appears. Which matter should we take up first? 3986. Okay. These are own matters. Yes, other side ready. We can dispose this of. Government, Mr. Goswami is always ready. Mr. Goswami, ready? Yes? Okay, that will cover. 3986. Yes, what is 3986? What is the cause of action?
Then, what? And then in the next case, there is the temple and the hall, community hall houses where they have things like that. And all in our land,
In your land?
yes. And America, that's money their fund. And the MPLA is also utilize their funds to, develop this land which belongs to us.
What is the relief you are seeking?
They,
It was not acquired.
public, like their.
The public health is the requiring authority. The acquisition has to be done by a due process of law. Did you initiate any LA proceedings? Then how did you construct over the Patta land? Pechi, how did you make construction over the Pounded Patta land of the petitioners?
I asked from the right, they were able to put every time.
Hmm.
Six of that activity.
Yes, please explain what is it?
That's 1995 and all community purposes. And there is a community called community that put the proposal for having this water scheme. So
Now, that is okay, but on the ownership of the land, what exercise did you undertake to ascertain who is the owner of the land? Circle Officer Mr. Goswami, what is the basis of your report? What have you said? No, regarding the ownership, if they are claiming that they are the owners having patta over the land, what was the basis of allotting the same to the PHE?
and
Hmm. Who are you? Who is respondent number 6? Okay. Okay.
And but and here was a big thing,
There was a
big thing.
fig tree. Okay. Okay.
But the people of the local area to make worship as Parambal Kati. Subsequent as it was developed to a religious land.
Okay.
So the present petition 2 and 4 donated to the people of the area.
Donated.
Yes,
Donation.
yes, pardon.
Verbal donation. Verbal donation under what law? Verbal donation under what law?
Page 98. My lord, so the people of the area constitute a committee and to part of the accordingly. It's,
This donation was in which year?
1996, man.
96. Where they were? They were not aware.
Because the of the president and not wrote the article. I usually do going on by. So it is known as so it was known as number of Sabha Mutsav. So month of March, Assamese month March, if Sabha was performing award or election. It's 1996. I give up souvenir and it's a copy of the souvenir. Where national number 2 rules and article in the year 2005.
But holding of a religious, Mr. Das, the holding of a religious program or a function, will it mean that they have given up their rights over the land?
They have right, why they're sleeping for so many years, man. Since 1996. Their submission is their does not know it. The picture number 2, user broke the article with the inner sovereign.
No, Mr. Das, that is the question which we are posing to you. The article is not related to the present activity. Article is relating to the religious program. No, but this activity started when? Regarding? No, this activity, the present one, which is the subject matter of challenge. 17.
Mondir was constructed, community hall was constructed by law. I have annexed photographer annexed my deputy. And my lord.
Yes, what do you finally want? Do you want compensation or what? For the land? Mr. Nath? Just a minute, we'll come to it. No, under that we have not gone to the legal aspect. We are now trying to find a solution. You would be satisfied with what? Fair compensation.
Ultimately, serious money, my lord. Let them record that 1/3 attendances of land, my lord. There is the question came up every time when the middle of the there's no difference. It was public set up money to spend. Let them record that part of 1/3 attendance.
What is your take on this, Mr. Goswami? What is your take on this? How do you respond to this? No, see, we have to go by the records. If the records have their name, and it's not like that 50 years, 100 years, they are not in use. They said that it was used for a religious purpose with their knowledge. That is okay. But now it's transformed into a different, it has become government property. Now, if it's become government property, you have to either acquire or buy it. Have you given any proposal? That you have said already. Let us see the circle officer's report. What was the basis of his report? Circle officer, do you have the records? Get the records. How did it process? No, circle officer, see, the PHE acted on a report by the circle officer. And circle officer had prepared the report based on certain materials. We want to see what are the materials. Did he make a due diligence exercise? Who is on record the owner of the land, number one? Or how did he come to know that this is public land or government land? See, at least you have to give a notice that you are not in use, we are taking over or whatever. If that you have not done, then the minimum is to pay them their fair compensation. You get the records. When can you get the records? We have this, we fixed this on 13th or 14th, maybe on 13th. Is it okay? You get enough time. Whenever you say, then you can say, we can have it on 18th, 18 August, 18 August. Okay. Heard Sri so and so. Now, how much is your land? Okay. And entire land has been taken away. Yes, please. Yes, yes. Yeah.
In one of the cases, I got the empty area development plan reflect when I checked the slide, the guidelines of empty area development fund schemes, and I have found they can be done with private land, provided the owner of the land give consent.
Consent, yes.
Number two, if it is built by the society, then society has to be registered. Here in his own affidavit, he has stated, my lord, it's unregistered society. He has stated in page 87, he has stated it's unregistered society. So these two things, number one. So for the elder case, the NG Ednagas case is concerned, same guidelines.
Okay, we'll look into
So
it.
it goes getting.
Okay, hard, huh? Hard so and so सबका नाम लिखना है. Yeah, do case petitioner. Sri and go or यहाँ भी लिखना. PP Das, respond number so and so. I Thakur for the BHE department and Goswami, State Council. Sri N. Goswami, Sri Goswami, the London State Council, is directed to obtain the records of the case pertaining to the initiation of the process whereby the communication dated, which one? Circle officer? Date 1/3/2008 was given to you. 1/3/2008 was issued by the circle officer. Is it 8? Then why these matters have been filed now, 22, 23? No, that is after the court's order. No, the initiation of the process. 2008. That I have here. Okay. List on 18.8. Okay, we'll see. Nath. Senior counsel. S. Chakraborty. उनका नाम है अलग में.
Has to be in terms of the policy decision. Similar issue came up before this one. And the have interfered with the decision taken. But in addition, that they are gathering maintenance that I said. 7 months they are not pursuing them. If they are pursuing, so that I
7 is covered, you say.
Our steps has been taken. And paragraph 15 of that doesn't, which gives us the as far as our action is as far as the
Okay. Yes.
background of litigation. Railway, before railway buyout, for manufacturing of papers, which has been used in the track of railway, we entered into an agreement in 1989. And at that time, what is happening a lot? Railway provides us land also near to where goods trade or state. So that loading and unloading can be very easy. But it is continuous process, since that we are, whenever the order comes, we manufacture sleepers and supply to railway. So first agreement you will also be find at page 38. Type copy my word.
38. 5082. Yes.
Of land, of
My first part I am just reading, made on 28 June 1989, between President of India and the demanded General Manager not frontier here in after for the government. Of one part of the almost construction not before the of the other part is temporary occupation of land belonging to government situated on at Shagi Road, Konsul area 8.3 or Digas or other or there above or for taking up of concrete sleeper factory for the period 1988 to 19 December June 1995.
Yes.
Because time to time extended for 50 time.
Hmm.
There are
Now what happened? What is your cause of action?
one of the present plan value as per the policy of the as per 1985
Demand notice for?
and we are ready land license, but as per the circular as per 1985 as per the circular that was held by the honorable court. Page 49 is the policy decision my lord. And my lord make article of page 52. The policy decision of India. And clause 5, fixing of land value. This is my lord. That's the language. Page 15. A market value, may I read the law?
Yes.
A market value, however, is quite to be taken from as it is value for working out rental income. This shall be fixed on the basis of allocation and market value of the surrounding area as on 1/1/1985. This is important. What we are saying, it has to be as per the thereafter I love page 54 and page 56 my lord. A market value could however be required to be taken fixing of rental serve as a base value for working out rental fee payable is fixed on the basis of land value of the surrounding area 1/1985 as defined from the revenue of the and or similar or the following. So whatever the land value on 1/1/85 which has to be taken into consideration. There are some communications we have made with the railway. The petition also page 77. The petition was disposed of.
Now what is your grievance with this? They said,
Deducted. Amount of 9,149. It is not as per the policy decisions. They have taken into consideration present land value. In fact, policy said it has to be 1/1/1985. And this honorable court that you also find at page 88. In the case of Daya Engineering, same question given before this honorable court. And this honorable court held my lord.
page 888.
Page 99. Not 99, page 100, para 18, 18. Para 18. Page 100. Consequently, you have to have observation that between notice of demand page 100.
Yes.
You have observation. Demand notice, notice of demand that is interfered with the direction to the regional railway to calculate the land value and the consequential licensing fee on the basis of clause 7 and 9 of the master proposal. That I wrongly typed it as 62. Till a licensing agreement will not enter into by the petitioner belong to the regional railway office. You also observe that if there does not enter its license, this is not the case, sir. We are. So this on the for business where business, and including whatever you want, is 70.
Page?
Is 70, my lord. And it's a deep principle. But what we have recovered. Yes, you is correct. Recovery of various licenses, case 70. You can work. Correct. For recovery of that's 931 revised license fee. It's not one cent to you fight out to say that it's reminder issue to.
See, here there are three components. In this 59, there are three components. One is license fee for the period 2008 to 2009. Second is 9 to 10. And the third is revised license for 2002 to 2008, right? So which component you are aggrieved? Now, what is the third component? What is this revised license fee? You contended, in spite of the policy decision of 2005, whereby the land value was to be fixed as per 1/1/1985, that has not been followed, and the assessment has been done by taking the present market value of the land. That is your case. Have you made an assessment as to not 72?
Regarding assessment matter, let them allow your ultimate interfere with the appeal order, let them assess it and decide whatever the way that will be allowed as per the policy. So many things they are taking into consideration.
Yes. Madam Sharma, see the matter, the lease as such between the parties have already been gone into by this court and WPC 3341 of 18. And the court has interfered by your action, whereby the basis was the market value was present market value was made the basis. We are bound by that decision. So how do you say that the decision is not binding? Page
98.
There are no plot of land can be allowed for commercial use by private parties without entering into licensing agreement. In the instant case, it is an evident fact that there is no licensing agreement between the petitioner and the respondent radio authority, and the petitioner has been allowed to use the land in without any interest, which is completely contrary to the three circular above mentioned. The land which have been allowed to be used by the petitioner is a land belonging to the respondent radio, which is a state. Within the meaning of Article 12 of the Constitution of India and under such circumstances, when the respondent in their own circular mandates their licensing agreement or a must before handing over a possession and in absence thereof, strict action will be taken against the hiring official. It is strange to observe how the respondent will have been permitting the petitioner to continue the use and operation of a.
What about page 38 in their case? In their case, what is page 38? Page 38, the license.
They are using cost for 8.34 because of land, and they are using additional 7.05 because of land. Apart from that,
No, from December 88 to June 95, this agreement was there. Okay, thereafter,
and to test renewal of the license file, database 5696, I have annexed from it. But there was, but they used that, there is no necessity, then lordship, so that license was never renewed thereafter. And apart from that,
was for December 8 to June 95. You said that there was no renewal.
from the LGT, yeah, there was also not same class.
Where are the renewals, Mr. Goel?
But I manage.
No, you have to. Yes. 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 No, now the stand is has been taken. We have to answer that stand.
But time to time it was extended.
Where have you made a statement?
The time here.
Where? The first thing in the reply should have been to annex the renewal. They have also made a further submission that you have made a request.
This one,
Hello, on their data, it is that they have extended it, because time and again they are using data that I have annexed one. 10, 15, they are saying about land license and all. Although the actual agreement was not, may not be entered into, but they are aware we are.
No, there would be two situations. One, they have, by their own action, have allowed to occupy the land used for the purpose of manufacturing of slippers. But you will be guided by what terms? There is no agreement. And therefore, we cannot say that there was a meeting of minds to reach into an agreement that what would be the rate. The first agreement, which you referred at page 38, you are connecting with a policy whereby the value of the land has to be taken as 1995, 1985, and this agreement has continued long thereafter. If there is no extension on writing, then the terms and conditions will not be there. What would be the rate? They are not saying that you are penalized for use of the land. That is not the. Now, what would be the rate? What would the rent? This is almost a rent.
But they were taking, earlier they were taking as per 90, that's a for the 9.
You bring this extension. We grant you a week's time.
Fine.
But you should have given this on the rejoinder. Heard Sri A. Goel, Learned Counsel, for the petitioners, as well as Ms. B. Sharma, Learned CGC, appearing for the railways. Full stop. While Ms. Sharma, while Sri Goel, the Learned Counsel, for the petitioners, has submitted that the issue is covered by a judgment of this court dated so and so, passed in WPC 3341 of 2018, page 88 में देख लीजिए date, comma, Miss Sharma, the Learned Standing Counsel, Learned CGC, has submitted that the facts are distinguishable. Full stop. She has highlighted that the agreement in question was for a specified period which had spent its force in June 1995, and even after numerous requests, no fresh agreements or renewal was done, and therefore the present demand cannot be faulted with full stop para. Sri Goel, the learned counsel for the petitioners, has submitted that he would place on record the renewal the documents relating to the renewal of the agreement for which he prays for and is granted a week's time. Let such renewal be placed on record by way of additional affidavit. We are giving you 1 week time. If you want some more, 1 week's time, bring it. Doesn't matter. Huh? 13 or besot. 13 to belek. 13, 14 alag, then 15 or probably sub belek. ठीक है, ये तो क्या belek? Yes. Item number 10. Yes, what is this?
Otherwise, is not for hospital, now we get second medical college. There were earlier round of decisions. Finally, final decision, whereby under one cannot stay away phone away. They were directed to notice, and after hearing, the Honorable Court had directed to first cooking orders. This sets of the petition is further same except few petitions, where petitioners are already evicted. All other petitions are they were some notices and they had filed their respective implementation. Right of hearing was given to them and their statements were recorded to the effect whether they are landless or not to come with that and get the benefit under the provisions of land policy. All the parameters have been compliant and finally the state orders in respect of each and every passed by the district commissioner. And then those state orders is discussed and reported in the report. So the one law point is what we is absolutely whether the state order is in accordance with law or not. To that extent, they make the something such manner to get back as a full manner. Because we are in a emergency manner.
Oh, there is an interim order what? Where? In the 1439, there is no interim order. No, these are all connected. Now we are taking up which matters? Okay. Who are appearing for the rest of the matters? 15 onwards?
Yesterday they filed an appeal. I want to file reply.
What the interim order? Interim order? Evicted.
Bylaws arbitrarily light has been cut off by. At one room they tried to evict.
No, they want it for a public purpose, for a TB hospital. How can you resist?
This is why now they say when they settlement,
Settlement where? Same area. Oh, then you file your reply. If you have filed yesterday, Okay. In your case, you are already evicted. Advocate commission is not for asking, Mr. Chaudhary. No, not for asking. You cannot just say for advocate commission. We have to make out a case. Which is your case? In your case, affidavit has been filed yesterday. Let him file the reply. Then why are you kind of other matters we'll see here? What are the other matters? No, let us segregate. Let us segregate. No, let us first segregate. Let us first segregate. No, Mr. Chaudhary. Mr. Chaudhary, first, please have the patience to listen to the code. Just go. Don't go on asking anything. We are trying to segregate the matters. Those matters who are already evicted and those matters where speaking orders are passed, which are the subject matter of challenge. We can go ahead with on the validity of the speaking orders. Now let us see the speaking orders. Make your submission regarding the what we'll segregate those matters. Which are the matters where speaking orders have been passed? Just tell us. Have you made a list? Mr. Chaudhary, for which are your matters where speaking orders? Only one matter. One matter. No, no. Okay. On that will give you time to file affidavit. That's not a problem. Now, which are the matters where speaking orders have been filed? Can you just identify? Speaking order, what are the other matters? Now, where are the speaking orders passed? Ten. Oh, 10.
Item 22, 23, 24. These are the matters where they are already evicted prior to filing of the litigation. So therefore, there is no speaking order doesn't get. So they can accept these matters in all other matters by the speaking orders and they are irrevocable. That is the punishment.
Okay. So speaking order, I think item number 10, 11, 12. 13. Who is appearing for 13? Thirteen, 14 are different. Then why 13, 14 different? Okay. 15, let us see 15. 15, Mr. Dhar. Sixteen, what order is passed in 16? Is there a status quo order? Status quo order. Oh, you maintain the status quo order. Let them file the affidavit. Yes, Mr. Dhar. No, item number 17. No, not 17. Not 17. 15. Speaking order is there. Yes, let us see. What do you say? 213. No, let him submit. No, no, he is not saying that. He is saying that the point of law would be addressed by the Advocate General after completion of your argument. That is obviously. Yes, Mr. Dhar. 94. 94.
And the application is in the correct position of the name and translate the application position. Let the expert to the court and look for information concluded that the and use thereof. Therefore, in view of the above, the settlement petition of Sri so and so Minal Hazarika, son of late so and so is hereby rejected and disposed of. The circular which
Where is the proceeding of the hearing?
proceeding of the hearing was not given to us also.
We need to have the proceeding of the hearing.
Now, if you comes to the judgment,
If we have served each and every document to them, and we have incorporated each and everything in our affidavit.
Okay. Yes,
Yes.
where in the affidavit
Yes,
is hearing, Mr. Dhar?
Yes,
Lordship,
so that our affidavit starts from running page number 97, my lord.
97. By the response number 2, 3, and 4. But before that, Lordship, if your Lordship comes to the judgment of this noble court, passed on 7/11/2024, the operative portion,
Page.
Lordship, page, it starts from page 57, and operative portion, Lordship, will find paragraph 50 at page 69. Page 69, para 50, Lordship.
$59.
59, 69, operative portion, paragraph 50.
69.
69, 69.
Yes.
Accordingly, this court therefore dispose of the instant batch of these writ petitions with the following observation and direction. The imperial notice under Rule 18 so issued to the petitioners to vacate shall be construed as notice issued by the Circle Officer Guwahati Revenue Circle to show forth why the petitioner should not be evicted by taking reports of Rule 18 of the settlement rule. The petitioners in the present batch of writ petitions are given the liberty to submit individual replies and substantiating the same with documents and such evidence as deemed proper, thereby showing cause that the petitioners have a bona fide claim of right involved in respect of the land under their occupation. And as such, the recourse of Rule 18 of the settlement rule is not permissible. The liberty given above is to be exercised within 30 days from the date of instant order. In the said replies, the petitioner herein shall indicate in which writ petition the petitioners were parties. The Deputy Commissioner Kamrup A is directed to give an opportunity of hearing the petitioner either personally or through their authorized representatives. The Deputy Commissioner Kamrup shall thereupon pass appropriate speaking order. The Deputy Commissioner Kamrup Metro is further directed to allot a particular area of his office wherein such replies could be submitted. A notice be hanged in the office of the Deputy Commissioner Kamrup and
indicating the area. The court further directs that upon the speaking order being passed, the Deputy Commissioner Kamrup Metro shall notify in its board about the facts that the speaking order had been passed for a period of 30 days. And from such notification, no coercive measures be taken, so that if the petitioners are aggrieved, they may avail remedies as permissible under law. So now the your lordship comes to again the speaking order. This is not a speaking order, lordship. As per the direction of this honorable court, this cannot be treated as a speaking order, lordship.
Let us see the report. That is why you are asking.
That is,
Place
that
the report.
let them produce that.
No, it is in the affidavit.
In affidavit.
You address, place the report before us. We'll come to Mr. Borpadari later.
Well, page 106, my lord, running page 106, that is a part of the affidavit. Response state affidavit, my lord. These are the materials pertaining to hearing. And my lord, page 107, these are the statements. We have to see the antecedents, whether they are really landless or not, my lord. Otherwise, anybody can claim, my lord, government land. Then statement of Tutumoni Hazoika, page 108. Yes. I am keeping it in mind, my lord, in my mind that I am not a civil court. I am a revenue authority exercising, my lord, a summary trial. Then the report lordship will find at page 112.
No, let him place it. We'll
Yes,
come
my
to-
lord.
Yes, let us see the report.
Report is lordship will find 112. I to get my statement, lordship may kindly. 108.
Yes.
Lordship got it on 108. I, Srimati Tutumoni Hazarika, wife of late Minal Hazarika, in sound health and with personal knowledge, do hereby give statement on today, 17/2/2025, attending before the Court District Commissioner, New Guwahati Court District, that the house of my husband is at Roha and my parental house is at Gulagat. My husband was working in the irrigation department as a clerk. In the year 1987, I came to Guwahati after my marriage with him. Although we stayed for a few days in a rented house in the year 1993, my husband encroached a vacant government plot of land measuring 14 lesses covered by flag number 97, village Ulugari under Ulugari Mauza. My husband was paying the land revenue and GMC tax since 1993. Since then, I have been staying in this plot of land along with my only son by constructing Assam type house. My husband was suffering from diabetes since long, and as a result of which both of his kidneys were failed and he died on 18/3/2024. In the year 2010, we also approached the Honorable Guwahati High Court along with the villagers after receiving the eviction notice. The Honorable High Court directed the District Commissioner to consider our settlement allotment. Accordingly, we have submitted our proposal, but before arriving at a decisive position, we have again received eviction notice from the circle officer in the year 2020. Again, we the villagers approached the Honorable High Court. This time also the Honorable High Court directed the District Commissioner to consider our settlement allotment after receiving the Kabula from us. In the year 2020, we again submitted Kabula. After the said direction, 2 persons of the same dag were able to get Miyadi Patta and 7 persons are at other various stages for getting patta. But we, the villagers, again received eviction notice in the year 2022. Before arriving at a decisive position of my husband's Kabula application, the said SDLC, LSC, again, the villagers we approached the Honorable High Court. My husband died during pendency of the case. This time, the Honorable High Court directed the District Commissioner to give hearing after receiving the individual application demand from us. Accordingly, I have submitted my application demand after death of my husband. This is my statement, Lordship. And now the speaking order, if your Lordship comes to this report submitted by the detailed report, page 112. In rest, Lordship, go to. In response to the letter under reference on the subject cited above, I have the honor to inform you that in pursuance to your letter stated above, I hearing above a hearing of the concerned party, that is Tutumani Hazarika on behalf of Minal Hazarika, wife of late Minal Hazarika, was conducted by the undersigned on 17/2/2025. As her husband has already died in the year 2024, as per her statement, consequently, the petitioner along with her representative learned advocate has appeared before this. And during the hearing, the petitioner representatives of the petitioner were heard and the statement of the petitioners were recorded. Mrs. Tutumani Hazarika, wife of late Minal Hazarika, is originally from Gulagat district. Her husband was also originally from Roha, Noagang district. After marriage, she came to Guwahati along with her husband in the year 1987 and started to stay in a rented house. Since the year 1993, they started to live on the disputed land. Her husband, late Minal Hazarika, worked in the irrigation department and he died in the year 2024. She is in possession of a quantum of land measuring 14 lessons by constructing a Hudson type house. She had filed Kabula petition in the year 2020, but the same has not placed before the SDLSC till date. On pedestal of the Chitha remark of Dag number 97 of village Ulugari, Moza Ulugari, it is seen that the land under dispute is reserved for TBO storage. Section 14.3 of the land policy 2019 states that the state government will not consider settlement of any government land in Guwahati city in order in other towns areas under possession of individual or other person merely on the ground that the person concerned is in occupation of such land, irrespective of period of such occupation or enforcement. It will be the policy of the state government to consider settlement or to evict such persons as the case may be. The section 14.3 of the land policy 2019 clearly envisages that mere possession of a government land for a certain period of time in Guwahati city does not guarantee settlement over the land, and that the settlement is purely the discretion of the state government. Further, as the government land is already reserved for the public entity, that is TB hospital, it cannot be settled with individuals. It is also pertinent to mention here that the land of the TB hospital has been proposed for the second medical college of Guwahati, that is Pragjyotishpur Medical College and Hospital. And hence this government land is very essential for greater public interest of the people of Assam. This is the report, Lord. Now, there are so many contradictions by the Deputy Commissioner himself, Lordship. In earlier occasion, the Deputy Commissioner has stated that this is not allotted to the TB hospital. After that, it was stated that yes, it was allotted to the TB hospital. Now, if your Lordship comes to page 134 of my reply.
134.
134, Annex 7. With
130.
134. With reference to the letter cited and subject cited above, I have the honor to furnish you with the report submitted by the Circle Officer, Guwahati Revenue Circle, Guwahati letter number so dated 22/12/2021 in connection with settlement of land measuring 1 kata 5 lesser covered by bag number 97 of village Ulugari under Ulugari Moga in favor of Sri Arun Kumar Singh, son of so and so. It can be noted that the proposed land is not allotted or settled in the name of TB hospital as per hand record available. And
Which is this land which has been given to this particular individual, Arun Kumar Singh?
Yes, Lordship.
Which
Of
is
the
this
same
land?
village, Lordship.
Huh?
Of the same area.
Now,
Same bag.
where do you get?
Dag number, Lordship, will find Lordship at the 1, 2, 3, 4, fifth line, Lordship. But land measuring 1 kata 5 lesser covered by dag number 97. All the dags are in 97, Lordship. All the lands are in dag number 97.
Yes.
Lordship, the fourth line, Lordship, from the top, in connection, land measuring, Lordship, got it.
Hmm.
Land measuring 1 kata 5 lesser covered by dag number 97 of village Ulugari under Ulugari Moza in favor of Sri Arun Kumar Singh, son of so and so. It can be noted that the proposed land is not allotted or settled in the name of TB hospital as per hand records available, and the proposal has been approved by SDLSC held on 11/12/2020 by resolution number 293 in compliance with the Honorable Guwahati High Court order dated 10/1/2020 in case number 12. So there himself stated that it is not allotted to the TB hospital. Therefore, so Arun Kumar Singh was given the, and another 2% has already been given patta lodging.
This DAG 97
Yes, Lord.
is comprises of how many acres or bighas of land?
Yes. For that, if Lordship may be pleased to come to our affidavit again, my lord, that is running page number 118. Running page number 118.
Yes.
There Lordship will find, my lord, this is the chita. My lord,
No, 118.
118 is the, my lord, type copy, translated type copy. And the downloaded copy, my lord, is available at 119. Downloaded copy is at 119, my lord.
Okay.
Now, if Lordship is taking up 118, Lordship will find it at column number 3, area bigha. Lordship got it, my lord. Lordship kindly see, my lord, it is 34 bigha, 4 kotha, 12.3 lesser, 37 lesser. This is the total area which is reserved, my lord. This is the total area of government land, government khas land, which is reserved for TB hospital. Now, TB hospital, my lord, that has been renamed, that in over that part and parcel of land, my lord, the TB hospital is no longer is in operation, my lord, and therefore the second medical college has come up. TB hospital has been renovated, my lord, to that extent. And it is going to be open, my lord, next month, my lord, formally open. Now, so far as, my lord, this document is concerned, which Lordship has just now seen, my lord, at page 134 of the reply affidavit, my lord.
Yes.
Because we cannot file any rejoinder to this reply, my lord.
Yes.
I can only submit, my lord, that this communication was an erroneous communication, my lord. In the earlier round of litigation, we have clarified it, and we have put this communication on hold. In fact, in pursuance of this communication, my lord, no settlement has been given to him. It is just a proposal. It is a proposal from the district commissioner to the government. Now, once it was detected that this was done erroneously, because the deputy commissioner was misled and he was given a false report by the concerned subordinate revenue authorities, and therefore this is put to hold. And this is, my lord, amply proved from the fact, because the petitioners are unable to show what has happened thereafter in pursuance of this communication. If this communication is taken to be true, I assume it to be true for the timing that it is true, then what would be the consequence of this communication? Definitely, my lord, this is a letter addressed to the government. Government would have accepted it. There is no document and record to show that the government has accepted this, my lord, letter, this proposal, and thereby going ahead and giving settlement or patta
Mr.
to this.
Pujari, though there is no occasion for this court to doubt your statement,
My lord,
but this statement of yours requires to be on record by way of an affidavit.
Yes.
You file an additional affidavit. This will have a
no, because this
this will have a serious bearing on the decision-making process. We know about negative equality, but
Yes.
negative equality will not allow
Yes.
that persons has been allotted land in the same area where you propose to have a new hospital.
Yes.
You may have done it erroneously, but what steps have you taken either to revoke this letter or to cancel this letter?
Yes, or either to
You
revoke or cancel.
put this on affidavit.
No, we will put it,
Where is the instructions? From where are you making this submission?
because in the earlier round of litigation.
Where? Where? Is it on record anywhere?
No, here it is not on record.
No,
because
earlier round of
I didn't-
litigation, earlier round of litigations had
Therefore-
culminated in orders, judgments. Is
Therefore-
it reflected?
Therefore, my lord, why I am making this submission, because we have filed our counter against the counter is reply.
No,
So if
see, in the rejoinder, they have taken a new point,
my lord,
which might give rise to the issue of discrimination. We are not on the issue of discrimination.
can
We are
file
on
it.
the
We will
issue
file it.
that whether you have uniformly dealt with all the
Yes.
citizens, and more important is if the entire DAG consisting of so many areas, bighas, is earmarked for a TB hospital, which has been nomenclatured now as Pragjyotish Hospital. We are not doubting the public purpose. But if it's a public purpose, you cannot allot to A and give reject for B. You cannot allot to anybody.
Cannot allow it. In fact, my lord, why I'm making this.
You file an affidavit.
No, we will file an affidavit to this extent, but lordship will find, my lord, from in earlier, in some other petitions, where they will project before this honorable court, that out of this, my lord, DAG number 97, some areas have, some plots of land has already been settled. It has gone further. It has gone further. They have already been settled. Now, it might have been settled to somebody. Now, the government, if we want those part and parcels of land, we'll have to acquire it because they have attained the status of a, my lord, patta holder. We will have to acquire it. But now, so far as these writ petitioners are concerned,
Those,
they are
settle-
trying to draw
those settlements were done when?
my lord, much prior, my lord, almost, my lord, 6-7 years ago. Yes. 6-7 years ago. At that point of time, my lord, it was lying, my lord, something, my lord, happened, my lord, they applied. Now, there was no, now this
So
needs.
this settlement of Arun Singh is in the year 2022.
No, this is 2022, this is a proposal. My lord,
Unless they have been able to lay their hands in the proposal, we cannot expect them to have, this is good enough to make out a case.
no, this may be, my lord, this is with regard to some other person, therefore I am making this submission, my lord. Because they will project all the materials available in their favor, my lord, to defend their case, my lord. Definitely, they will do it, my lord. But whether, my lord, it is with regard to this petition.
In which other cases they have been placed on record instances where settlement has been made?
Yes, my lord, in some other cases are there, my lord.
Where? Who is appearing? You produce. Have you dealt with those? Mr. Borpujari, have you dealt with those averments?
Yes, my lord. Those
done.
yes, because those amendments have culminated into passing of this order by this honorable court, my lord. Because lordship, therefore lordship will kindly see, my lord, the order, my lord, the judgment, my lord, judgment and order passed by this honorable court in the earlier round of litigation. My lord, this is a common judgment and order.
711.
Yes, my lord, 711. Everything has been taken on board, my lord. These aspects of the matters were heard.
Let us see.
Yes, my lord. Lordship will kindly see, my lord, from page
57.
yes, page 57 onwards.
Yes,
Because
please.
this order,
After that, may
this
We'll
order,
come back to, we have not finished.
this order starts from, my lord, page 20 onwards. There are backs of writ petitions.
Page
Page 20. Page 20 of the writ petition.
20 of the writ petition.
Page 20.
No, let us see
Yes.
we are not on the names, we are on the contents of the order.
Yes, my lord.
Order starts at page 57.
57.
Let us see where are the averments and where, how is it been dealt with.
My lord, from paragraph number 3 to paragraph number 39.
We have read this.
Yes, my lord, all the writ petitions have been, my lord, called out, my lord.
No, we have read this. Where is the averment that somebody has been settled? How has it been dealt?
Well, it was there in the writ petitions. This honorable court had taken into consideration their aspects of the matter. This honorable court had put a point blank question to them that you are to assail your rights. You were to, my lord, establish your right. You cannot put the gun on some other source. Some other person might have been settled. Government will take care of it, my lord.
This submission of yours will work in other matters. Here is a submission we are dealing with, that on an area covered by DAG number 97 is earmarked for TB hospital, which is now being re-allocated or nomenclatured as Pragjyotish. Now the requirement will not change.
Requirement will not change.
You might even require more land.
Absolutely.
Now in the said DAG,
Yes.
can you allot or settle areas to somebody else? We are not saying that will give them a right
Yes.
for Sikh settlement.
Yes.
But the policy which you have adopted has to
Yes.
be uniform.
Should be uniform. Yes. Should be uniform.
Now,
But
what
now,
steps have you taken? Either to revoke or cancel this proposal,
well,
or either to acquire the land in question?
yes.
were those decisions taken? What were the factors?
Yeah.
What consideration?
Consideration was, my lord, that they had filed settlement for, my lord, Kabula. Settlement petitions,
Their
my-
Kabula were also pending since 2010. One judgment as back as 2010,
my lord, only,
2020. We are not asking you that you have to accept. You have
definitely,
rejected them, but you have to reject everybody's.
everybody.
You
Now,
cannot-
my lord, prior to filing of these writ petitions, even in the earlier round, my lord, this 7/11/24 order, prior to filing of the earlier writ petitions, my lord, those.
Mr.
two-
Borpujari,
those two or three points have already been settled.
let us do it systematically.
My lord,
These averments they have brought out in their rejoinder.
please, and that,
You said there is no provision for filing. You may be correct, but this is a new point.
yes,
We'll ask you to file additional affidavit to
and
deal with
additional
this point.
affidavit.
And what are the other cases where the aspect of settlement to others have been highlighted?
Yeah.
And at what stage? It is in the writ petition stage or rejoinder stage?
My lord, that they will have to, my lord, point it
No,
out.
you have said that in few other cases.
Few of the cases that plea has not been taken, my lord. That plea, they will have to raise that plea. They will have to show, my lord.
No,
that
no, you said that
disparity
it
is
has
there.
been taken.
Discrimination is taken.
No, you have said that this plea has been taken, that somebody has already been settled.
Plea has been taken in the earlier writ petitions, my lord, which are not on record.
No,
Only the-
here, in these proceedings.
No, here, please, no.
Mr. Chaudhary,
Yes, my lord, in two or
have
three
you taken
matters.
this?
In two or three matters.
Yes. And petition filed, thereafter we filed the additional affidavit. Thereafter, government has filed affidavit in opposition.
No, in the additional affidavit, have you taken this point?
Yes, taken this one, thereafter affidavit in opposition filed. They are silent about what is submitted before the court.
Yes.
Nothing said about Dr. বিশ্বাস, Arun Chanda, Madan Mohan বিশ্বাস, Arun Singh, nothing has been said. Now today they submit before the court. I mean, kiss it.
Mr. Borpujari, if you've got a chance and not rebutted, may not be in Dhar's petition, in Chaudhary's petition, what is your reply?
Then.
If you have not rebutted, we will construe that you have nothing to say. We cannot give you chance after chance.
No, definitely, but my lord, we have stated the facts, my lord, so far as their hearing is concerned, my lord. So far their hearing is concerned, because they are trying.
See, our question of fact will not become different in a
No,
different matter.
absolutely,
If
absolutely.
one instance of a
Yeah.
particular individual is taken up by Mr. Dhar as well as Mr. Chaudhary, Dhar takes it up in the stage of rejoinder affidavit. You may say that we are not aware. In Chaudhary's petition, what is your reply?
So this petition, we are reply because we have already filed a reply because it is altogether factually defined because they are already evicted.
Now, how have you dealt with this averment regarding a particular individual proposal being sent
Then-
in his?
Then I will have to draw my lord's attention to that writ petition. my
Let us
lord.
see.
Yes, let us see that writ petition, my lord.
Lordship, before that, if I may take your
Yes,
lordship to
so
page
let us
hundred
go
and
one by
twenty.
one.
Page 120, this is the minutes of the meetings, when it was held, lordship, 21/2/2022. And thereafter, lordship,
Page?
page 120. Of their affidavit.
120.
20, minutes of the meeting was held on 19/2/2022. And letter was issued on 21/2/2022. And now if your lordship comes to page 132 of my affidavit. which is
Just a
like
minute, please. 120, yes.
120, it is the minutes of the meeting held on 19/2/2021 in the conference hall of the Deputy Commissioner, Kamrup Metro District regarding allotment of land with Second Medical College, Guwahati.
Yes.
Now, if your lordship comes to page 132 of my rejoinder.
Now, why are you showing 120?
Lordship, this is what, lordship.
Why are you showing 120?
I'm showing lordship because to draw your lordship kind's attention to the letter dated 17/3/2022 at
Page?
page 132 of my rejoinder. Minutes of the meeting was held on 19/2/2022. Thereafter, this letter was issued at page 132. Lordship got it.
Yes.
With reference to the subject, letter subject cited above, I have the honor to furnish here with the reports submitted by the Circle Officer Gauri Revenue Circle by order dated 28/2/2022 in connection with the settlement of land measuring 2.88 R covered by drag number 97 of Bulu Village Ulubari, Mauza Ulubari in favor of Srimati Hamida Khatun, wife of so and so. It can be noted that the proposed land is not allotted or settled to in the name of TB Hospital as per hand records available in the proposal has been approved by SDLC on 11/12/2025 resolution number 296 in compliance with the what I could. Lordship, the minutes of the meeting was held on 19/2/2022. Thereafter, this letter was issued, Lordship. Proposal regarding settlement in favor of Hamida Khatun.
Same area.
Same area. Minutes of the meeting was held on 19/12/2022, and that this letter was issued on 17/3/2022.
What is the area? 1.2.88 R.
88 R.
If you convert in Bigha Katha, how much it will be? 2.8 R?
Yes, my lord.
2.88 to one কথা কিবা হ'ব 5 lakhs I think so.
My lord, 2.81 R will be, my lord, 2 kotha 1 lesser.
Let us see this order of High Court 10/1/2020.
One কথা 10 is
What is this 10/1/2020 High Court's order? So, Barpujari, do you have the copy of this 10/1/2020?
Yes, my lord,
Because they have
10/6/2020 should be, my lord.
whatever it's
Yes.
corrected to
Yes, my
10/6/2020.
lord, that was,
292 of 2020.
yes, this is, my lord, passed in the earlier round of litigation.
Now you bring all these
Yes, my lord.
because
yes, yes.
if they have
Yes,
fallen
yes,
fallen
yes,
back
yes.
on a High Court's order,
Yes, we will
we
review.
have to see what was the High Court's order.
Lordship is absolutely correct, because
Simply we
lordship is
cannot find fault with them. We have to see the High Court's order.
correct, because
If we find that interpretation appears to be correct, we may not find fault. So far as the Malafide is concerned.
absolutely,
But
absolutely.
so far as the legality is concerned, we can still take a call.
Therefore, in sum and substance, lordship will find from their affidavit in reply, they are trying to show discrimination. Therefore, these are the few instances. Lordship has seen page 134. Page 134 pertains to my lord Arun Kumar Singh. Similar is the case with page 132. That is one Hamida Khatun.
Right.
Then again one, my lord, page 130. 130, lordship will find this is with regard to Srimati Firuza Begum.
yes.
Where, my lord, proposals have been made, my lord, by the district authorities to the, my lord, government and the revenue department to consider their proposal for settlement. Now, what has transpired thereafter, this is only to that limited extent, we will bring it on record.
See, all the orders which they are trying to rely upon
Yes.
are invariably referring to some High Court's order.
Yes, High Court, sir. Definitely, we will bring it down.
Make a compilation
Yes, yes, my lord.
for
Yes,
the court to examine.
absolutely.
What was the direction of this court?
Absolutely,
How have they acted? And since the other side is harping on
Yes.
the issue that this proposal have gone after minute submitting, could not have been.
Yes.
And if there is an High Court's order in favor of Arun and Hamida,
Yes.
there are High Court's order in favor of the petitioners also. If file Kabula, those will be considered. Either you reject or you accept, that's a different matter.
Therefore, we have rejected it. Therefore, my lord, the last order, they have already filed their Kabula's representations. Those will be treated as representations for the purpose of deciding the proceedings under 18.
That is exactly what
Yes.
this case hinges upon.
Yes,
You have to take an uniform standard.
yes.
If it's in the same area, you reject for them and you accept for some.
No, my lord, lordship, the distinguishing factor here is that, my lord, these writ petitioners, they at no point of time, my lord, no proposal was made by the district authority to the government for, my lord.
No, district
requesting for
authority is also in this side, your side.
Yeah. No.
You cannot say that district authority for some had given the proposal, so we had considered.
No, I am making this submission because my lordship will see, my lord, this Hamida Khatun, Firoza Begum, Hamida Khatun, and Arun Kumar Singh are not before my lord.
Because they were not
Yes,
served with
yes.
the eviction of
They are not aggrieved.
No, they are not a gift. So they are trying to draw an inference that since you have taken, you have favored them at one point of time, why you are leaving us? This is the sum and substance.
No, we'll not take that.
Yeah.
We are aware of negative equality.
Yes.
We are saying that this area, entire area is required for
We could not have.
required for an hospital.
Yes, yes, we could not have gone to that
In
extent.
this case
Yes,
is
yes.
distinguishable from other cases of
Yes.
negative equality.
Yes,
Here, you say that public interest is at large.
yes.
We are also very much concerned with public interest.
Good.
We want that the area should be free of any encroachment which is meant for an hospital. But petitioners are rejected, they're clean. But you allow somebody to
Yes, yes.
occupy land in
Why,
that area.
why we have done so?
And not only allow, you legalize,
Okay,
you give
yes.
settlement.
So we will bring on record, my lord, so far as these three documents are concerned. Because they have brought in record, my lord, these three documents. We'll have to traverse, my lord, these only three papers.
Any other,
If any others are, my lord, they will have.
any other?
They are the dominant relative.
All the document.
No, any other instance? We have got three instances, Arun,
Yes.
Hamida and Firoza.
Yes,
And Madan Mohan.
And Madan Mohan বিশ্বাস.
Where have you stated?
In my eviction.
And they have not replied.
After filing the additional.
Oh.
They filed the,
সুনীল রেজাকের পর এখন ক্রিকেট নিয়ে আছে এই এর পেন করে ক্লোজ করে সুনীল রেজাকের
onto item data.
item
19, Lordship, may kindly take up item number 19.
Lordship, in our result there also, in page 124, we have stated who were
Item number?
19.
Let's see 19.
Well, item number 19, my lord. We filed the additional affidavit on.
You filed additional affidavit on
On 21
21/5/2025. Yes,
And government has filed the affidavit in opposition
19/6/2025.
25. And we made averment that, my lord, lordship kindly. Yes, my lord. Come to the document number, my lord. $98 16 Annex 16
Page
page 319.
319.
Yes, my lord. The patra is, my lord, page 321. Annex 17.
319 is a part.
Your logic, can you look at the Assamese version? 321, my lord. 8/12/2021, no? 2021, my lord. Then, my lord. And Jamabandi copy. Shown, my lord. New DAG number 989, Madan Mohan বিশ্বাস, my lord. Assamese version, I am shown, my lord. And Bankim Chandra বিশ্বাস, my lord, Assamese version. Your logically original, my lord, 990, my lord. They changed the DAG number also in the year 2021. And one important thing I want to show your lordship, my
This
lord.
321 is in favor of whom?
My lord, Bankim Chandra বিশ্বাস.
No, no. 321 is somebody else.
Yes, my lord.
Not
I-
Bankim.
I want to show one important
Three.
point, my lord. In the
Madan Mohan, this is Madan Mohan.
Madan Mohan one, another is Bankim Chandra.
Madan Mohan Biswas, my lord.
And Bankim Chandra বিশ্বাস. I want to show important thing, my lord. They have produced, my lord, Jamabandi copy of the last 3 years, my lord. 23, 24, 25. If you also go there, affidavit in opposition, page 422, my lord. 422. There are two page number, my lord. One is 332 and continuous with
422, yes?
Yes, my lord. 422, my lord. 3 years Zamagwamdi has been given, my lord.
Yes, 422 is Chita.
Sita, sorry, my lord.
Sita,
Sorry,
my lord.
Sita is.
Yes.
Government land cannot be depicted in a Jamabandi.
Sorry, my lord. Sita copy, my lord. I nazano bhai.
No, no, no.
23, 24, 25, my lord. Note of land record assistant TB hospital, my lord. My humble submission before your lordship is that, my lord. Normally, what happened, my lord? This is the data operator inserted the, my lord, this, my lord, document, my lord. They have produced original document for last 30 years, my lord. When it was TB hospital given, when it was not. If the TB hospital given, my lord, before that, 2021, my lord, then, my lord, your lordship has already said picture are different, my lord. Because, my lord, in one report already read my lord Arun Kumar Singh, they has categorically stated the land is not belong to the TB hospital, my lord. And another important thing is that, my lord, in this page 424, my lord, our DAG number is 97, my lord.
Yes.
Have you lordship got it? Minutes of the meeting held on 9/2/2022 conference hall of the Deputy Kamrup Metropolitan District regarding allotment land with Second Medical College, Guwahati. Lordship, kindly come to directly point number 3. Allotment proposal of land measuring 55.75 R covered by DAG number 90 Ulubari Mouza is approved by the Special Divisional Land Advisory Committee subject to acquiring NOC from Animal and Husbandry and Veterinary Department. Allotment of government proposal land measuring 12.30 R, 0 biga 4 kotha 11 covered by DAG number 98 Village Ulubari Mouza is approved. Allotment of land covered by DAG number 250. Where is 97 DAG? There is no proposal for 97 DAG. Nothing is available, my lord.
This is with nomenclature, my lord. 97 is always there.
Where is my lord? I am submitting from record, my lord. There be affidavit, my lord.
Annexure F, my lord, in our affidavit, so far as Annexure F is concerned, my lord, kindly see the paragraph, my lord. Paragraph 22, page 250.
Page 250.
No, these areas appear to be addition to 97.
97.
These areas appear to be, there are other lands belonging to the animal husbandry. Those have been reallocated in the name of the hospital. There are other lands.
Lordship may kindly come to page 342 of that affidavit, my lord. We will clarify, my
Do
lord.
you have a map, kind of a cadastral type of map?
Right
Have
now,
you,
we do not have.
have you put on record? We want to know where is DAG number 97, where is DAG number 90, where is DAG number 98?
No, my lord, 98, they are not concerned. Why
No,
do
no.
we- Yes.
No, why you was in serial number 4, you have proposed for allotment of government land of 12R covered by 98. And these are all in connection with having the second medical college.
No, second medical, my lord, what was the intent for bringing this document on record? The intention is plain and simple, my lord. Therefore, lordship may kindly come to page 342 of that affidavit. Why we have got this down?
342.
342, paragraph 22 of that affidavit itself. By bringing this document, we want to demonstrate, my lord, that the name of TB hospital has been changed. Only to that extent. They are concerned with DAG number 97. I am also concerned with DAG number 97. Why DAG number 98 has been roped in by them? They have nothing to do with.
Their document, my lord, this is the proposal.
Yes.
That is why I'm
The
taking.
proposal is with regard, there are so many
Let
resolutions
us say
taken.
97.
There are so many.
We are not on their concern. We say that while changing the name or taking a new name,
Only to that extent.
no,
like-
there are, you have also taken certain proposals
Yes.
for certain other lands. Those lands have to be contiguous. We just want to see from the cadastral
Yes,
map.
yes, definitely.
Only for that purpose.
Definitely. But so far as these documents, my lord, what the relevance of this document would be?
Have you got the records of the entire transaction records?
Yes, my lord.
Records you have?
Right now, we do not have, my lord, we will.
Get the
prepare.
records.
Yes, my lord, definitely. And
Because
lordship
The requirement or need for filing additional affidavit may not be there since you have already responded to Mr. Chaudhary's petition.
No, my
And these were within your knowledge, you have preferred not to respond. If you have preferred, we cannot force you to respond.
no, my lord, so far as.
Bring the records.
No, we may find an additional affidavit to clarify, my lord, under what circumstances, because this has already attained finality. What Pata is issued, my lord, Pata is already there. They are already settlement holders in terms of, my lord, regulation 9 of the land revenue regulation. So we will have to acquire it, my lord. That is one aspect of the matter. Now, so far,
That
my
is
lord,
silent in the affidavit, my lord, nothing else.
now, so far as item 9 is concerned, where lordship has taken a perusal, my lord, so that to the extent that a proposal was mooted, my lord, what has transpired thereafter, we will find an additional affidavit, definitely, my lord. Now, so far as these are concerned, my lord, we will have to acquire it, my lord. Rightly, wrongly, they have been allotted, my
Mr.
lord.
Borpujari, you have got a feeler of what is in the mind of the court
My lord.
regarding, we are also concerned with the entire area of
Absolutely.
tag number 97,
Absolutely.
as well as certain other areas which you have tried to bring it within the ambit of this particular hospital. We have nothing to do. We have, in fact, we may be with you on the same page,
Right.
but we are on the aspect which they are trying to highlight.
Yes, definitely. Now, lordship has seen, my lord.
We grant you 2 weeks time to file additional affidavit. On the next date, you need to have everything on, all the original records with you.
Yes, absolutely, my lord. Absolutely. My lord, we will be filing additional affidavit, my lord, in all the cases, my lord, where they have brought in.
Yes, you can file an additional affidavit in one of the matters, craving leave of this court to rely on the others.
Absolutely.
We want on record, on affidavit.
I'm so obliged, my lord.
Oh.
So we'll be
Copy
filing,
will be
yes, definitely.
Copy served on.
Definitely. Absolutely.
Heard three so and so, huh? During the learned counsel for the petitioners have highlighted the aspect that while speaking orders have been passed against them, there are instances wherein land within the same DAG number 97, which is said to be allotted for the second hospital, which was earlier reserved for the erstwhile TB hospital, have been proposed as well as settled with certain other individuals. Full stop. Though the aforesaid aspect does not appear to have been clearly dealt with by the respondents in any of their affidavits. Full stop. To bring clarity in this matter, let an additional affidavit be filed by the respondents meeting the aforesaid aspect. Full stop. Liberty is granted to file one consolidated additional affidavit, copy of which may be served on the learned counsel for current learned counsel appearing in all the cases, all the writ petitions.
Yes, ma'am.
The Sri Borpujari, the learned standing counsel revenue, is also directed to obtain the original records of the case on the next date. Full stop. Para. As agreed upon. List on.
No, let's send it be in the
19th
19th of August, my lord.
19 August.
Prior to that, my lord, let me file my affidavit in item number 15, my lord.
What?
Let's make an observation, my lord. WPC 2130 of 25.
In the meantime, further exchange of pleadings may be done by the concerned parties. Para interim order passed earlier to continue till the next date of listing. But 19th don't, will not adjourn on 19th. We'll try for us.
My lord. At least 1 week ahead, my lord, we will be completing the.
And let
planning.
them be ready with them.
Absolutely, my lord. I'm so obliged.
Yes, yes.
13-14, let's say, I need some time. My lord, that land proposal was sent by the circle officer to the deputy commissioner.
What is this, what are these matters about?
My lord, it is the Assam Industrial Development Corporation. They acquired-
Assam?
Assam Industrial Development Corporation. They acquired my 4 kata, 18 acres of land for construction of approach road by IDC for Kamakhya biofuels. By executing an agreement on 18/11/2021 without.
You want to
further
file your
request.
response?
Lordship, not responded that.
Not responded, my lord. AIDC has
I
already
appear
responded.
for AIDC, my lord. My reply is already on record. Time was sought on the last date to file a rejoinder. No rejoinder has come in.
No, I need time, my lord.
We have already filed, my lord.
Mr. Handy for,
I'm for the district administration, my lord, deputy commissioner.
you
My lord,
you have filed your response? No.
No, my lord, we have, no,
Will you file or you'll bring the records? What will you do?
lordships. Let me file the affidavit.
Now, but the affidavit filed by the AID, they said, my lord,
But in 151574, the
Both are
last
similar
order
matters.
says that the pleadings are complete.
Lord.
Respond numbers 2, and 3 have filed affidavit. Reply has been filed.
yes, filed, my lord.
You are for whom? Respond number 1. Last occasion, the court has observed that pleadings are
I'm for
complete.
respond number 4, 5, 6, and 7. 4, 5, 6, and 7.
What do you want now? You would like to file affidavit or what?
Lordship, my lord, that one proposal, my lord, land proposal was submitted by the circle officer to the deputy commissioner. My lord, that proposal was, my lord, that next, my lord, the SLC meeting, it will be a proposal will, my lord, place. My lord, it should be, my lord, it is, my lord, held, will be held in the next, after 10 days, lordship.
Okay, then let the proposal be taken. Let us see the outcome.
This kind of correspondence are being made for last 4 years.
Let us
Where
see what is the instruction.
affidavit filed by the AIDC, they said, my lord.
Instruction of which date?
This is June, lordship. 26 June. Earlier, my lord, that land was given to him, my lord, allotted to him, my lord, it was, my lord, Jalatanko.
No.
That plus, my lord, could not be, my lord, that could not be taken.
Sri J. Handik Learned State Council has submitted that as per its written instructions dated 26/6/2025, our meeting for considering the proposal for allotment of government land
To both the petitioners.
in for the petitioners would be held shortly. And was scheduled to be held on 2/7/2025.
If 2/7, it could not be held, my lord, that some of the my lord, members are.
He has informed that the said meeting had to be deferred and would be held shortly. Full stop. In view of the above, list these cases after 10 days. We fix a date
I know.
after 10 days. List on
Can it be on 20, lordship?
20.
15, 20.
Yes, list on 28.
Well, if any documents, my lord, I have received, my lord, I want to brought in record.
In the said during the said time, the state respondent can bring on record any development by way of an affidavit.
The Land Advisory Committee has already recommended
That was it.
in the year 2022, man.
Next.
Objection.
Fifty. Yes.
This is regarding that allotment of land.
Yeah, Jorhat, who is appearing?
I'm appearing.
Okay. That lady who had lost her husband,
Yes,
ONGC employee.
yes.
Okay.
He may not paid all the money, all the allotment money amount was there, that was paid by her husband. Only regarding transfer, because it has to be transferred in her name.
But
That
there were
is a-
notices given to you. You did not take any steps.
Yeah, in a steps, my lord. No, death certificate I have given, but it has to be transferred in my name. I have given the death certificate, then thereafter.
Mr.
petitioner
Das, what is
submitted-
your status now? It has been allotted to you.
No,
My
no,
lord, yes, my lord. And
I am in possession
after-
of the land.
No, my
There
lord,
an
that is
interim
not
order.
correct, my lord. I am in position. And my lord, after my lord sold it, mutation has been granted. And thereafter separate pata has also been issued. And after 2 years, when my lord, I got permission for erecting boundary wall. When I started construction of boundary wall, then only my lord, they have approached this honorable court. Then also without my lord impleading me as party respondent. Thereafter, on my lord, suggestion made by this honorable court, my lord, they have impleaded me. And they have not challenged the sale deed then also. We have filed our counter affidavit in the year 2018. And thereafter, after 2 years, they have, my lord, challenged the sale deed by way of amendment, my lord, of the writ petition. So, my lord, initially in the year 2012, final notice was issued to the writ petitioner, my lord, for taking necessary steps within 10 days. That has not been taken by the writ petitioner, my lord. And that letter has also been not annexed by the, my lord, writ petitioner. And that letter has been annexed by only respondent number 4, my lord. I have annexed, my lord. And thereafter in the year
Okay,
2014, my lord.
let us hear. They moved. Agor note to ki hol note ta asile. They note ta asile. Moi na honisile na hiru guest. Not to nine
Thereafter in the year 2014, my lord, after 2 years, my lord,
Yes.
finally that has been cancelled, my lord. And thereafter, again, they have filed one representation that was also rejected in the month of March 2014, my lord. And thereafter, they are sitting over it till the year 2018, my
Okay,
lord.
let us hear Mr. Das.
My lord.
We have lost our notes.
Well-
Some notes.
My lord, you also will kindly see, my lord, the allotment letter at page 33.
You have to please narrate the facts.
Yes, my lord, page. Well, there was in a lottery, my lord, lottery for allotment of land, petitioner has submitted a amount of rupees 2,000, that your lordship will get it at page 32. On petitioner's husband, on 15/11/93. For the purpose of participation, she has paid rupees 2,000.
Your husband had participated
Yes.
in the lottery in the year 1993.
93.
Thereafter,
Thereafter, my lord, on 13/12/93, my lord, page 33,
is
33.
33.
She has been informed that the Jorat Development Authority takes this opportunity to congratulate you on becoming a proud owner of a residential plot in so and so. Then, my lord, category C, approximately plot area is 200 and schedule of payment is there. So her husband has paid the amount by 13/2/95, all amount paid. Initial amount was paid on 24/1/94, rupees 20,000.
This communication is dated what? 13 December.
Yes. Allotment letter and schedule of payment. Schedule of payment, rupees is there, my lord.
Yes, yes.
In pursuance to this, my lord, total amount 49,000 has been paid. First is page 30, she has paid 20,000. Her husband has paid 24/1.
The entire amount has been paid.
Entire amount has been paid. By 13/2/95.
By 13?
2/25, 95.
Okay. Yes, thereafter.
Accordingly, my lord, she has taken over the position.
When did your husband pass away?
Hello?
When did your husband?
Husband expired on 29/3/2006. Hello,
As per death certificate, my lord, 26/2/2005, my lord.
27, yes, my lord.
26 2
2005, my lord.
Certificate.
2005.
My lord.
Okay, doesn't matter. 26.
I stand corrected.
No, it doesn't matter. 26
16
to
to 2005.
26 to 2005 he passed
Five.
away. Okay,
That's
then
that certificate will show. Then the petitioner submitted an affidavit regarding the death of her certificate of her
Okay.
husband,
page.
page 48, on 2012/2007.
Eight. Yes.
Then she visited the office of the respondents on several occasions, as stated in paragraph, for the purpose of transfer and registration of the land. Because after this, my lord, the Jorhat Development Authority is required to transfer it and for the purpose of registration.
Okay. The last payment you had made on 13 to 1995
13 to 95.
during the lifetime of your husband.
Yes, yes. Amount has been paid. Only my lord, requirement is that they are to transfer the land in the name of the widow petitioner, and then thereafter, my lord, they are to register it. So once the payment has been made, how can they cancel it, my lord? And cancel it and give it to a person who is nobody, my lord. How he has been allotted?
Thereafter, what happened? You visited the
Petitioner applied, my lord, at page 52 on 19/11/13 for transfer of land in her name, and the page 52, and the circle officer okayed it. May be allowed.
Where do you get it?
Page 52.
No, the endorsement.
That is at page 53 last. May be allowed, circle officer said.
Yes. Yes.
Then, my lord, page 56. Application for land sales permission.
Yes.
And in the meantime, my lord, the permission was granted on 7/3/2014. That your lordship will get it at page 60.
Page 60.
64. 7/3/24/14, permission was granted by the Jorhat Development Authority and the Additional Deputy Commissioner and the purchasers. Page 64, your lordship will get it.
Yes.
But before that, my lord, the impugn order was passed at page 60.
The first payment which you had made was payment for what?
Which one? First payment.
First payment in 3 installments.
Yes. First is 24/1/94.
No. You said that the amount was finally paid on 13 to 1995.
By all payments.
What was that payment made for?
That is for allotment of land.
No, and
That
this
is the
payment
condition of allotment
and
of land.
this payment at the permission, it also.
Permission is for the purpose of, my lord, registration of the land. For the purpose of registration of the land. And here two aspects are there. One is, my lord, it has to be transferred in the name of the petitioner who is a widow of the original.
Originality, yes.
So this is that, then thereafter permission has to be given by the DC and all for the purpose of registration of the land. So this permission was granted on 17/3.
In 64, though it is nomenclatured as permission for sale, sale you say that was done long before. This is only giving us entity.
That is the allotment order. Now they are saying that they will provide a sale certificate, then thereafter go for registration. This was a procedure followed.
Okay.
But before that, they have cancelled it. 7/1/14, my lord, page 60.
Page 60. 60.
60. Your lordship will kindly see, this has reference to our, I'll read this one, a small letter. This has a reference to our above quoted letter dated 5/11/2012. Since even after lapse of more than a year, you have not responded in the required manner, the allotment of the land earlier granted in your name, which is described below, is hereby cancelled. Now this 5/11/12 letter, your lordship will get it at page 117.
One.
7. This is addressed to petitioner's husband. That you that on your request and upon payment of consideration amount of rupees, the plot of land allotted so and so as detailed below was allotted to you by so and so. But in spite of receipt of the same, you have not come forward for registration of the deed of conveyance till date. Your failure, but this is addressed to her husband at so and so, my lord. Then we replied,
Okay, we'll come back.
yes.
Come back at 2.
Cancel the allotment letter to
Sorry for the delay. Yes. Unlisted is any. Unlisted, he said, unlisted. Okay.
Alert, in these circumstances, I have come to the order of granting permission. Granting permission, I have come, my lord.
117.
7/3/14, my lord. Permission for registration of sale deed.
That you have already shown at page
That we have shown.
64.
Yes, then we have given a reply on 21/14, that is at page 61. We have given a reply at page 61. We have stated everything right.
61 is your reply.
Yes. 21/2014. May I read this one?
Just a minute, please.
Detailed reply I have given. From paragraph
61.
61.
61 is not there. Page.
Page 61.
Yes.
Then we have stated, my lord, from paragraph 3 onwards, issued to register the sale deed after obtaining necessary permission. But in the meantime, my husband was transferred to Gujarat, and while he was in Gujarat, he suffers from serious ailment and ultimately expired on 2005 due to cancer. Then paragraph 5, I have duly informed the JDA about the death of my husband and requested to take necessary steps for registration of sale deed.
But this is 2018.
2018, yes. No, 2014.
No, this is 9th February 2018.
No, 2114.
Page 60, it starts at page 60.
61.
61, there is no fresh.
There is a consolidated amended petition is there.
Consolidated amended has got something else. Sixty-one is a part of your what affidavit? 61 is a part of your representation of 2018. Can you
Maybe 55 or 56, my lord.
55.
55 or 56.
56 is that representation, 9th of February,
Yes,
2018.
yes. No, 2014, my lord. 20.
Which letter are you referring to?
2114, my lord. Yes.
20?
2114.
Oh, presentation of the thing is, sir.
2114.
Presentation 61.
Page 50.
Please.
Page 50. 50.
Yes,
Not 61. It's 50. 2114 you have written to the chairman.
yes, ma'am.
To chairman, yes.
Yes. My lord, I have given information, paragraph 3, my lord, paragraph 5. I have stated, my lord, that JD about the death of my husband and requested to take necessary steps for registration. That letter I have already shown. Then due to non-registration of sale deed, I have again visited the office of the JDA and I have again asked to submit another affidavit. And accordingly, I have submitted an affidavit on 3rd December 2012 before the JDA stating the names of the other legal heirs, so and so. I have received, paragraph 7, received a letter issued in my name, white letter dated so and so, 5/11/12, but received very lately, and after receipt of the letter, I have visited the office of the JDA and obtained a joint sale permission application where my member secretary also put his signature as joint applicant. Said application was submitted before the DC and forwarded to so and so. The SDC, paragraph 8, my lord, the SDC has also submitted report for transfer of the state land in favor of the purchaser along with the place map, etc. So the permission was granted ultimately, as I have shown, my lord, at page 64. My pagination may be wrong, I don't know, my lord, here. That is
Yes.
on 7/3/14. The permission was granted. Page 57 maybe, my lord. Has the lordship seen that?
That is 64. 7/3/2014.
7/3/14.
64.
The permission was granted.
Now, if the allotment was cancelled in January 2014,
January, yes, it was.
how was
cancelled on
permission
the-
granted in March 2014?
Because we proceeded much prior to that, ultimately it culminated in the order dated 7/3/14.
Okay.
So your lordship will kindly see how this was cancelled at page 60. In my pagination again, my lord, I am afraid.
60.
Yes.
Not
The
60. It is
allotment-
not 60. There is serious discrepancy with the pagination. It's not
No,
60.
That letter
But
dated
my
5/11/12.
line of has been referred, my lord. That is the consolidated, my lord.
No, we have checked up both consolidated as well as earlier. Pages are not
Page 60, my lord, 7/1/14. allotment has been cancelled.
That we have seen.
But how can they cancel the allotment? Your lordship will kindly see the allotment condition at page 33. Page 33. Then page 34. The page 33 is the allotment letter, and page 34, my lord, last. If payment, paragraph last but two, my lord. If payment as per schedule above are not made within specific date, our allotment will be cancelled. How can you cancel? The payment has already been made. As per the terms of the letter, you have cancelled it and you have given to a person who is, how they have selected that person, I don't know. And I have stated specifically in my writ petition at paragraph 12, in the year 2018, my lord, on specifically stated, my lord, lordship will kindly see paragraph 12 of the writ petition. The second week of February, one unknown person trying to remove fencing of petitioner's land. Then we raised objection. Then we came to know that it has been allotted to some person. So accordingly, we came before this court. Subsequently, we came to know the name of the person. The paragraph 12 I stated. And in the second week of February 2018, it has come to the notice of the petitioner that one unknown person was illegally trying to remove the boundary fencing of the land in question. And when the petitioner raised objection and informed about the allotment of plot of land in their favor, the person informed that the respondent number 3 has taken steps to re-allot the said plot of land to him. So this allotment was subsequently done on a certificate in the year 2016. In the meantime, the correspondences made by the petitioner, this has not been looked into. The permission granted by the authority not been looked into. Permission also granted, my lord. And after the cancellation, it was only cancelled. Allotment was not made. The allotment was made in the year 2016. That your lordship will get it at page 82. How he was selected? Who was selected? Suddenly you will give the allotment to him.
82.
Prime land.
82.
82. My lord, again either 82 or no. Okay.
Not 82. See, you have filed a consolidate petition. Why don't you refer to the consolidate petition?
I am referring to consolidated.
Confusing.
Maybe 75, my lord.
What is the date?
Date is 13/1/2016.
What is there?
There, my lord, this is the certificate that the position of the scheduled problem land is under Sonal 2, Sri Ujjwal Jyoti Doctor. This is the allotment.
To the private respondent.
My lord?
To the private respondent.
Private. Allotment of land has been given to the private respondent. 2016.
Okay. This is also the subject matter of challenge.
Yes, sir.
In the consolidate petition.
Yes, sir. Then sale date on 17 to 16. He gets allotment, he gets permission for registration also. Same date has been done within a period of 1 month or so. Page 87 in my petition. You have finished. Consolidated petition, it is 87. Sale date registration.
Who is in possession of this land?
Position is, it is in my position because we came before the court. Court granted status quo. If they claim position, I don't know. Because the land is empty, it is this status quo order is there. I'm in continuing, I go there, I see. Others have built their houses because of not granting permission, my lord, the petitioner is facing problem.
Okay. That is all?
Your lords, my lord,
That is all?
yes, affidavit in opposition by JDA. They admit the sale permission was granted. And paragraph 10, my lord, stated that it needs it. Doesn't say how this respondent number 4 was allotted. Regarding sale permission, my lord, granted they admit this.
Who is the private investment number?
4, my lord.
4. You say that the basis of allotment of to R4 has not been disclosed.
Disclosed. And it is not known. Suddenly, my lord, land allotted, he gets permission, he goes for sale registration. This is, my lord, very high-handed action on the part of the authority in cancelling the allotment after taking payment of the, my lord, the amount prescribed in the allotment letter. After receiving the full payment of only action was that they are to sign a sale registration, then get the permission which they have got it. But after the order of cancellation, this has been done in a very high-handed manner, causing much harassment to the petitioner whose husband was allotted the land. Therefore, I pray, my lord, the lordship will cancel the order of interim order of cancellation of the allotment and also the order of allotment in favor of the respondent number 4, including the sale deed registration. All the
Let us see your relief you are claiming in the consolidated writ petition.
Yes. Interim order of cancellation of land. Subsequent letter dated issued by the respondent number 3.
Okay.
All the 4. Legal.
Yes, Jorhat.
The in order, this 53.
Page?
53. Annex 11.
Yes.
Srimati Ritapara, order of 6 cases. This has the reference of our above quoted letter with 511 to square. Is even after lapse of more than a year, we have not responded the report manner. The allotment of the land earlier granted in your name is respect below is hereby cancelled. And you see the enclosed herein. Photocopy of the earlier letter dated 511 to 12. This letter will be seen logic. This letter has been annexed by the respondent number 4 logic in their affidavit finding the discussion.
In page, this case,
Then counter affidavit also there.
Page
Annexure
117.
Document D, my lord, as flag mark. My lord.
511 we have seen already, 117.
That letter was given to the admin of the petitioner law. Where read law.
Yes.
Second paragraph. However, a discharge of putting.
But husband passed away a long time back.
2005 years.
2005, husband passes away. You write a letter in 2012 to the husband.
But did not aware of the fact that he died.
Cancellation has been done in the name of the petition. Cancellation done in the name of the petition, the Rina boy.
Yes.
The letter was issued to the petitioner's husband law, but he did not turn up. That is why.
And what process did you adopt to choose Mr. Das's client? Okay, Mr. Das. Anything else, Mr. Wilson? For R4?
My lord,
Yes, what do you say?
my lord. Although the petitioner has annexed my lord, in my page 60, my lord, in the writ petition 7/1/2014, whereby my lord, the allotment was cancelled. There in the bottom, photocopy of the earlier letter dated 5/11/2012 addressed to you. That is there, my lord, but that has not been annexed, my lord.
That has not been?
That has not been annexed by the petitioner, my lord, and that is an important letter, my lord, where reflects, my lord, the scheme of the Jorhat Development Authority and why they are going to cancel, my lord. So this is an important letter, my lord, and it was concealed, my lord. However, my lord,
Which letter? 511?
5/11/2012.
5/11/2012 we have put on record.
My lord,
We have gone through it.
my lord, my lord. But the scheme that the needy people were allotted, that is reflected in this particular letter, my lord. Now, my lord, thereafter, the petitioner has filed the reply, wherein, my lord, paragraph 7 in my consolidated writ petition, my lord, page 62.
Yes.
She admitted that she has received that particular letter, 5/11/2012, my lord.
Page 62.
Page 62 in consolidated.
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 Yes, 62.
Paragraph 7, my lord, of the reply of the petitioner, my lord. That is the reply dated 12/1/2014.
62 paragraph?
Annexure 12. Paragraph 7, my lord.
Starts with what? In the meantime.
No, my lord, that I have received the letter issued in my name, hide your number,
No,
so
no.
and so.
You are referring to the consolidated petition.
My lord,
Consolidated petition.
that is the letter, my lord, dated 21/2014.
60?
62, it starts from 61, my lord, Annexure 12.
Please be like board. Most. Page code again. Peter 61, Peter 62. At page annexure.
Annexure 12, my lord.
Yes,
The
at
relevant
62.
paragraph I am referring, page 62, my lord.
Paragraph 5.
Paragraph 7, my lord.
7.
My lord. May I read, my lord? That I have received a letter issued in my name by your number so and so, which was signed on 5/11/2012, but received very lately, and after receipt of letter, I have visited the office of JDA and obtained a joint sale permission. So, my lord, she received this letter, and the letter indicates that 10 days time was granted to take necessary steps for further action, my lord. That was not taken.
Now, my lord, and since the repetitioner failed to take necessary steps, my lord, accordingly, her allotment was cancelled by letter dated 7/1/2014. And thereafter, my lord, they have filed a reply and which was considered. And another order was passed, my lord. That is at page 66, annex of 14, my lord. That is 21 March 2014. That is.
Yes.
Here, my lord, your petition dated 21/1/2014 is rejected. The earlier order dated 7/1/2014 of this authority of cancellation of the plot stands. For refund of your deposit, if any, you may apply to this authority within 7 days from the date of receipt of this intimation. That is not under challenge, my lord. Now, my lord, the allotment was cancelled on 7 January 2014 and sale permission was obtained on 7 March 2014. And in that is, my lord, annexure 13, page 64.
Yes.
Here, my lord, it is specifically, my lord, stipulated that this permission is valid for 6 months. And within 6 months, there was no action, my lord, for registration of sale deed, my lord. Thereafter, my lord, I applied in the year 2015, in the last part of 2015, my lord. That was cancelled in the January month, and my lord, finally.
No, Mr. Das, your submission cannot be accepted that no action was taken for 6 months. See, 7/3/2014 is the permission.
Yes, my lord.
But prior to that, on 7/1/2014, the allotment has already been cancelled.
My lord.
Where is the scope to take further steps?
My lord, my humble submission is that petitioner might have, my lord, challenged that cancellation order during that period, or may file appropriate application before appropriate authority to challenge the cancellation, my lord. If she has taken the such steps within a reasonable time, my lord, my appearance need not be, my lord, dragged into this litigation, my lord, because I have come into picture in the year 2016 only, after a lapse of 2 years. And as per, my lord, allotment letter, my lord, I have deposited rupees 3 lakhs to the Jorhat Development Authority, my lord. That is, I have annexed in my counter affidavit, my lord. Page 118, annexure 3, my lord. Annexure 3 and 4 are the receipts, my lord, whereby I have deposited total amount of rupees 3 lakhs. That is on 13 January 2016 only, after 2 years, my lord. And thereafter, certificate of allotment has been issued. And, my lord, an employee has been authorized to, my lord, get the permission and to, my lord, execute the registered sale deed, my lord. And that is, the permission is at page 127, annexure 7, my lord, dated 2/2/16. And thereafter, my lord, sale deed has been executed on 17 February 2016, my lord.
Yes.
This sale deed is under challenge, my lord. Thereafter, on application, mutation has been granted, and also perfect partition has been granted, my lord. Periodic patta has been, separate patta has been issued, that is annexure 9, my lord. Page 132. That is on 6/12/2016. The separate patta has been issued, my lord. Your lordship may kindly see page 133, the comment part, my lord.
One.
33, my lord. It's annexure 9 starts from 132. Second page of the patta, my lord. Here on the comment part, my lord, last column it is recorded, my lord. This separate patta has been issued on partition on the basis of possession in respect of the land measuring 15 less of new tag number so and so, my lord. So, my lord, my possession is recorded by the revenue authority, my lord, and that cannot be disputed, my lord. And I am also paying the land revenue, my lord, in respect of that, my lord. Annexure 10 is the land revenue receipt, my lord. In the year 2018, my lord, the Jorhat Development Authority, my lord, granted me the permission for erecting boundary wall. That is on 12/2/2018, my lord. Page 138, my lord. 138. And after getting the possession, my lord, mutation was granted, separate patta has been issued. I have developed the land and fencing was also erected, my lord. When I went to, my lord, raise the wall, my lord, boundary wall, removing the fencing, then, my lord, dispute has been come up, my lord. They have obstructed me, my lord. And they come to, my lord, file this repetition without implementing me as a party, my lord. And thereafter, I have been implemented and I have filed, my lord, my counter affidavit, my lord. And later on, my lord, I have filed my counter affidavit in the month of November 2018. And thereafter, in the month of November 2020, after 2 years, my lord, they have filed, my lord, amendment petition for, my lord, challenge the sale deed, my lord. And if sale deed also is set aside, my lord, then also, my lord, separate patta will remain in force, my lord. Mutation has not been challenged. And, my lord, so, my lord, my humble submission is that this writ petition is not maintainable on 2 counts, my lord. One is, my lord, there is a concealment of material fact, my lord, and there is disputed question of fact regarding possession, my lord. And, my lord, a registered sale deed which was, my lord, registered by following due process of law, same cannot be challenged on the basis of an allotment letter, my lord. And there is most unreasonable losses or delay on the part of, my lord, petitioner, my lord. She has challenged the letter of January 2014 in the year 2018, my lord, after 4 years. And sale deed has also been challenged after 4 years, my lord. And when the amendment application has been allowed, my lord, this honorable court observed that, my lord, there is an observation in the IA, my lord. In 2098/2020, my lord, the order dated 27/9/2023, IA Civil 2098 of 2020. Here, my lord, in paragraph 5, it is stated that be that as it may, for balancing the claim of both the parties, this court is of the opinion that the interest of justice would met by not applying the principle of relation back to the amendments to incorporate it on the basis of the instant order. This court further keeps the point of maintainability of the writ petition on the question of delay and losses open. Now, my lord, in this regard, my lord, I am relying 2 judgments. One of this honorable court, my lord, and another is of honorable Supreme Court, my lord. On delay part, my lord, I am referring to the Chennai Metropolitan Water Supply and Sewerage Board and others versus TT Murali Babu, report in 2014 for SCC 108. Here delay and losses on the part of petitioner is discussed in paragraph 13, 14, 15, 16 and 17, my lord. I am reading paragraph 16 and 17, my lord. Although it is relevant, 13, 14, 15 is also relevant, are also relevant, my lord. Paragraph 16, my lord. Thus, the doctrine of delay and losses should not be lightly brushed aside. A writ court is required to weigh the explanation offered and the acceptability of the same. The court should bear in mind that it is exercising an extraordinary and equitable jurisdiction. As a constitutional court, it has a duty to protect the rights of the citizens, but simultaneously, it is to keep itself alive to the primary principle that when an aggrieved person without adequate reason approaches the court at his own leisure or pleasure, the court would be under legal obligation to scrutinize whether the lease at a belated stage should be entertained or not. Be it noted, delay comes in a way of equity. In certain circumstances, delay and losses may not be fatal, but in most circumstances, inordinate delay would only invite disaster for the litigant who knocked at the doors of the court. Delay reflects inactivity and inaction on the part of a litigant who has forgotten the basic norms, namely, procrastination is the greatest thief of time. The second law does not permit one to sleep and rise like a phoenix. Delay does bring in hazard and causes injury to the lease. Now, 17, my lord, in the case at hand, though there has been 4 years delay in approaching the court, yet the writ court choose not to address the same. It is the duty of the court to scrutinize whether such enormous delay is to be ignored without justification. That apart, in the present case, such belated approach gains more significance as the respondent employee being the absolutely careless to his duty and nurturing a lackadaisical attitude to the responsibility and remained unauthorizedly absent on the pretext some kind of ill health. We repeat at the cost of repetition that remaining innocuously oblivious to such delay does not foster the cause of justice. On the contrary, it brings in injustice, for it is likely to affect others. Such delay may have impact on others' ripened rights and may unnecessarily drag others into litigation, which in acceptable realm of probability may have been treated to have attained finality. A court is not expected to give indulgence to the such indolent persons who compete with Kumbhakarna or, for that matter, Rip and Twinkle. In our considered opinion, such delay does not deserve any indulgence, and on the said ground alone, the writ court should have thrown the petition overboard at the very threshold matter. So delay is in this case also after 4 years of cancellation, my lord, they have approached this honorable court, my lord. And due to the unreasonable delay in approaching this honorable court or challenging the impugned order, my lord, my entry has been come into, my lord, this litigation, my lord. And another, my lord, judgment of division bench of this honorable court, my lord, that is WBC 263 of 2023, my lord, regarding concealment of fact, my lord. Paragraph 13, my lord. I am relying paragraph 13 and 42.
Thirteen.
This is observation, my lord, only. The Honorable Supreme Court has time and again held the litigants who approach the courts by indulging concealment of material facts should be repelled and dealt with strong hands. Now, my lord, all the observations have been, my lord, summed up in paragraph 42, my lord.
Paragraph
42, my lord. Internal case 17, my lord. On the facts of the present case, following principles emerge. It is the bounden duty of the court to uphold the truth and do justice. Every litigant is expected to state truth before the law court, whether it is pleadings, affidavit, or evidence. Dishonest and unscrupulous litigants have no place in law courts. The ultimate object of the judicial proceeding is to discern the truth and do justice. It is imperative that pleadings and all other presentations before the court should be truthful. Once the court discovers falsehood, concealment, distortion, obstruction, or confusion in pleadings and documents, the court should, in addition to full restitution, imposes appropriate
These
cost.
are not observation by the division bench.
My lord, division bench, my lord.
Sorry, you have not read it properly. These are Supreme Court observation.
My lord, ma'am.
This is all quotation. You should refer
My
to the
court-
Supreme Court.
Quotation that
You
has
refer
been,
to the Supreme Court.
no, yes, my lord, my lord.
They're not the wordings
My
of the
lord, my
division
lord.
bench.
In this judgment, my lord, it is reflected, my lord.
It is not 42. It is,
No, no.
the judgment is Sanguman. It's there,
So, my lord, my humble submission before your lordship
but
is that
otherwise in this judgment, paragraph what?
in this judgment, my lord.
Paragraph
page 42.
15. 42 is not of this paragraph of the judgment, it's paragraph 15.
In this judgment, my lord.
Paragraph 15, where that 2012 Supreme Court has
Yes,
been
my lord.
quoted.
Yes, my lord. Yes, my lord.
Yes. But let us read what is 42 is
My lord,
the principles have been
my lord, sum up.
summed up. Huh?
My lord.
Okay.
So, my lord, in 42, subparagraph 4, my lord, it is clearly observed, my lord, once the court discovers falsehood, concealment, distortion, obstruction, or confusion in pleadings and documents,
Now, what is the falsehood in this?
my lord, my humble submission before your lordship is that the letter dated 5/11/2012, that is an important document, and that she has also received that document. Although she has annexed the letter dated 7/1/2014, wherein it was a part of the 2014 letter, my lord, that was not annexed with the letter dated 7/1/2014. And my lord, in the pleadings also totally silent about, my lord, that letter, my lord, 5/11/2012, my lord. So it was my humble submission that, my lord, that is a concealment, because that letter was a vital document, my lord. Your lordship may consider or may not consider, but that was a, my lord, important letter for considering the issues, my lord, of the, my lord, whether the cancellation was reasonable or not, whether opportunity has been given to the petitioner before, my lord, cancellation or not, my lord. And, my lord, my humble submission is that, my lord, I am in
See,
possession.
you came into the picture much later.
My
You
lord,
are
my-
not on
my
the
lord.
decision-making process of cancellation.
My lord.
This, though it's a very valid point, it has not been taken up by the Doha Development
My
Authority.
lord. My
This letter has been addressed to the husband who had died at least 5 years or 10 years prior to that letter.
My lord.
There was no requirement to reply to the letter. And on affidavit, in this writ petition,
Yeah.
petitioner has annexed an affidavit
My lord.
of informing.
My lord.
We have not seen that it has been denied.
My lord.
If the affidavit was subsequently made, backdated, put on record only to make out a case, that has no denial from the judge. You are not aware of this. You are a private respondent.
My lord.
You might say that, yes, my allotment is in accordance with law.
My lord.
How were you selected? You have not answered a very important point.
My lord, I have filed an application, and on the basis of that application, that was filed in the year 2015, my lord, on the basis of.
Why you? Why not somebody else? So far as
My
petitioner
lord,
is
that,
concerned,
that may be.
so far as
answered by-
petitioner's husband is concerned, it was by lottery. It's
My lord.
admitted.
My lord.
And it's also on record that payments, everything was paid,
lord.
everything was made.
My lord. I have also paid, my lord. I have also paid. And what happened, my lord? If she challenges the cancellation order, my lord, in time, there is no scope for allotment the same land to me, my lord.
That we have understood.
And my lord, there is also subsequent development till the year 2018. Mutation was granted on the basis of, my lord, title deed and possession. Thereafter, my lord, separate porta has been issued. I am paying the land revenue, my lord. So there is subsequent development, my lord.
Okay. We have to consider this.
And separate purpose has not been, my lord, challenged. Mutation has not been challenged.
Anything else?
No.
Would you like to?
Only one aspect of what will note that page 64, that permission granted, that has not been cancelled.
But it automatically stands cancelled after 6 months, my lord.
Stop it. Finish it.
64.
Yes. This is the order for granting permission, my lord, in the name of so and so, for the purpose of so and so. This permission is valid for 6 months. This permission letter is issued for so and so. This has not been cancelled within the stipulated time. Then, my lord, then thereafter, my lord, they have cancelled this impugn letter has been issued. And this
64 of
letter-
which?
This letter has been issued in the name of the petitioner. When was the land allotted to her? Is 60. Addressed to Rina Bora. The land was never allotted to her.
Which page are you referring, Mr. Das? Which page?
In except 13, my lord, of the petition.
Which petition? There are two petitions, all
Yeah.
pages.
Here is 64, my lord, in consolidated, my lord. Amended petition, my lord.
Page 64.
64, my lord, in amended petition.
That 7314, your lordship was already seen there.
64 is in the midst of something. Not 64 of the amended.
Maybe 57, your lordship. 57 or
58.
57, 73.
yes.
57, yes.
This validity was for 6 months. 6 months. But prior to that, they have cancelled it, addressing the letter to the petition. If it is addressed to the petitioner, the land has to be allotted in the name of the, transferred in the name of the petition. When was it done? And your lordship will kindly see,
Where is the name here?
name is in the impugn order, that is
No, here at page 57.
57,
3773 2014.
yes. Down below.
Down below where the name?
In the right side, my lord.
Right side.
Right side below, my lord.
Okay. Okay, Rina Bora.
Yes. And paragraph 10 of the affidavit filed by the Jorhat Development Authority, in my page, it is there at page 72. Where we have stated that first week of February 2018, some unknown person started encroaching my lands. And to that manner, they have responded in this manner. Paragraph 10, your lordship is in of the affidavit filed by the JD.
Okay.
To the diploma.
My lord, further, no reply has been filed to my counter affidavit matter.
We have not misled this court. We have stated every facts, whatever we could gather from the
Okay.
petition.
Very just in a council. Step by this hard data. And Goswami. State Council for Representative of the Jorhat Development Authority. And UK, that's first one was 6, first one of 4. 4. Hearing of the- We'll have to reserve the judgment. We may not have time now.
Obliged.
But what is it?
Well,
Okay, that's
next
good.
two items is mine, my lord. Can it be taken on Friday or any other date? My lord?
We'll see. What's the, we'll give some dates. Not the person. Thank you.
Sir, this is also Jora development of it. Let me take it on. Thank you, sir.
Yes, what is this unlisted?
My lord, I'm sorry, my lord, in the morning I had mentioned it, my lord. My lordship has allowed regarding eviction, my lord.
Yes.
Lord, we are challenging a notice of eviction, my lord. My lord may be pleased to find the notices that page 73, my lord.
73.
My lord. Series of notice, my lord. Some have received, some have not received yet. Lord, this is a notice subject for eviction of the illegal encroachment in the Doyang Reserve Forest, my lord. It is in Uriam Ghat, my lord, in Golaghat district.
Yes.
May I read, my lord? It is hereby notified that you have illegally entered into the Doyang Reserve Forest situated under the Jamuguri Regional Forest Office, and by cutting forest on excavation, you have destroyed the forest resources by changing the forest land into agricultural land. Though the said act, you have completely violated the Assam Forest Regulation 1891 and Section 2425 of the Assam Forest Regulation Amendment Act 1995. You have committed unlawful act by clearing the jungle in a reserved forest without the permission. As per under Section 72 of the So-and-so Act 1995, the Forest Department of the Government of Assam has been authorized to protect the government forest land and also to evict the illegal encroachment. Therefore, you are hereby directed through this notice to vacate the said forest land along with all your belongings within 7 days from receiving the instant notice. If you do not vacate the said forest land within the time period by the stand notice, eviction exercise will be conducted under the Assam Forest Regulation 1891 for the sake of conservation and development of the forest. My lord. My lord, we are, my lord, residing in the said area. My lord, our forefathers from last 40, 50 such type of areas, my lord. And my lord, admittedly, we do not have any patta in our name, my lord. Till date, it has not been given. But only the case is that, my lord, when we were there, whether this is a forest land or as a revenue land, my lord, that demarcation exercise till date has not yet been done by the government. Suddenly, my lord, when this notice has been issued, then only we could learn, my lord, that this is a forest land. It is their stand, my lord. But as per, my lord, our instruction, my lord, as we are residing in a revenue land, my lord, therefore the government has time to time extended the benefits as it has been provided to the other part of the state. Our names also been enrolled in the voter list also, my lord. And some, my lord, Prime Minister's Abbas Yojana residence and the house has also been allotted. My lord can verify some of the, my lord, few we have, my lord, managed those orders, my lord, but most of the person has been given the said benefit of Prime Minister's Abbas Yojana, my lord. My lord may be pleased to find allotment certificate, my lord, is at page 287. My lord. This is one of such certificate, my lord, is at page 287. Hereby approval is given for construction of home. My lord has got it, my lord. 287 and it's a 5, my lord. Hereby approval is given for construction of home under the Prime Minister Awas Yojana for the financial year 2024 to 25 to so and so. For the construction of the home, an amount of rupees 1,30,000 will be released and deposited in your bank account in 3 installments. Apart from that, you will receive 95 days of job under the MNREGA as well as the toilet under so and so mission. Purified water connection under Jal Jeevan Mission and cooking gas under the Pradhan Mantri Ujjwal Asani. All the technical and other help for construction of your home will be provided to departmental office and employee. So, my lord, in the next, in similar manner, my lord, this type of notice, allotment certificate of the allotment had been issued. Now, my lord, our case is that, my lord, although, my lord, if we are not entitled to reside in the said land, as per the provision of the law, my lord, admittedly, and what I have to submit fairly before my lordship is that, my lord, field it, my lord, no any patta has been, my lord, allotted to any of the petitioners. But, my lord, only thing is that if my lordship may goes through the notice, only a 7 days, my lord, time limit had been provided, my lord, which it would be a very difficult, my lord, for us to move away with our permanent structure and the residence. My lordship has already gone through, my lord, that the issue is there. Now, my lord, if any such required exercise of demolition is required to be carried out, my lordship is well aware, my lord, as recently the Honorable Apex Court has also, my lord, formulated a pan-India guideline that a minimum of 15 days notice period is required, my lord. Now, my lord, may be pleased to find the notice has been issued on, my lord, 24/7, and the, my lord, time limit, if we calculate 7 days, my lord, it will come down to 1st of August, my lord. So already, my lord, today we have come to know that those persons, my lord, who has received the notice on 20th of, my lord, July, their, my lord, houses has already been demolished today and eviction has been carried out. So we are also, my lord, apprehending that, my lord, as a human being, my lord, within 7 days, it will be very difficult with our family, children, utensils. It is very difficult, my lord. And my lordship has already examined a similar issue, my lord, not pertaining to this area, but as regards the forest land. And my lord, just for a, my lord, reference, if my lordship may be pleased to find a similar order, my lord, is at page 337, my lord, 336, my lord. 336 is the starting of the order, my lord, and the operative part of interim is at page 337, my lord. Paragraph 7, my lord. There is also, my lord, land pertaining to the forest, my lord, if I am not, my lord. Forest Department has entered appearance, my lord. Lord, the exercise of the demarcation, my lord, is also required to be carried out, my lord.
This order is on a different context. They were issued patta.
No, my lord, some of the persons, my lord, those.
Here, it's your admitted case that you do not have in patta.
My lord, when we do not have the patta, my lord, I cannot, my lord.
No, the reason of granting or not granting or refusal to grant an interim order reflects on the
Order itself, yes, my lord.
reflects on the order, and it is dependent on the facts of the cases.
That's why, my lord.
That is why we have just seen the first paragraph.
Correct.
The submission, and it was on the prima facie basis. It was submitted that many of them had patta. So on that consideration.
That is correct, my lord. That is correct. But here is a case, my lord, wherein.
No, so far as your first submission is concerned, the aspect of time, that is perhaps one of the consideration which we'll make. And we'll hear the learned AG also. Yes, Mr. Take care.
If they give an assurance that they want 3 more days time, I have no objection to that.
The impugned notices of 24/7.
24/7.
Today is 29.
In fact, those where we have issued the notice on 20th, the eviction is done today. And before the eviction, about 70 to 80% of the encroachers. They have removed their belongings and they have left. And all these people, in most of the cases, have additional lands in their own respective native places. And each of the person here are having lands from 10 bighas to 300 bighas. So this is a huge nexus going on where they are cultivating various types of crops for commercial activities by demolishing the actual forest plantations. So not a single day, actually, they should remain. So
Are you having a residential property here?
Milord, residential property, we are, Milord, not seeking any cultivation or what respected advocate
Where
general
have
has
you,
submitted.
where have you stated that your residences are there?
Milord, in paragraph paragraph 3 at page 23, Milord. Page 23, Milord, paragraph 3. Milord, there are huge numbers of petitioners, Milord. So just in the village and our residents as we are residing therein, that has been mentioned, Milord.
Residing.
We are not saying that we are cultivating or other lands are there. Only our residents, Milord, which are there. That protection, Milord, we are asking for only, Milord. Milord, the houses, Milord, which has been built by with the government money, Milord, taxpayers' money, Milord. That and Milord, our specific instruction is that we are landless people, Milord. In the as my respected advocate general has submitted, Milord, that in other part we have land, that we do not have land, Milord. Then by name it can be verified today nowadays also, Milord.
Yes.
My lord.
So 7 days, still 3 days are left. So far as this place is concerned, Negheri bill. So 3 days, if they remove, fine. Otherwise, another 3 days, if Lordship directs, I have no objection. Otherwise, this is forest land. No notice is required. In spite of that, 7 days notice has been given. A offense has been committed by them under section 24-25.
Now, for the offense, you can take action. For the removal, we are just concerned. 7 days is less.
3 more days, Lordship, no difficulty.
Another 7 days.
Another 7 days, Lordship, lot of things may change.
No, we'll have an undertaking from him. He said so.
Only in
Supreme Court
respect of
guidelines, 15 days. And you have said that most of them have already left.
There are two forest reserves. One is Negheriting, other one is Uriam Ghat.
This is Negheri.
Negative, Milord.
Negheri.
Number, name, village name.
Here
Number
it is
2.
Negative.
Number 2.
So here the due date is 1st of August. So on first, the eviction process would have started here because the notice itself says you kindly remove it.
Give them another 7 days time to remove.
Now, Milord, if we go by the provision of the regulation, Milord, regulation does not say that we are required to remove or the government is have gone through the regulation.
The regulation according they should be arrested and put behind bar.
That they can do, Milord, but not our demolish our structures, Milord.
No, forest land.
Milord,
There is no two opinion about forest land.
My lord, but one thing is there, Milord. As for our instruction, Milord, till date, Milord, when our forefathers and now we are the offsprings, Milord, no proper accurate Milord demarcation has been done. Now, whether it is absolutely forest land or not, from the notice also it is not very clear, Milord.
See, you are the litigant before us. You show some document that prima facie we can state that this is not a forest land.
My lord, that is the
In fact,
difficulty
in some
because,
of the
Milord, we do not have
You
to-
are the one who's approaching the
we
court.
have to establish before.
At least some prima facie demonstration.
In some paragraphs,
Other case which you have relied
My
upon,
lord.
they have fixed the pattas.
Yes,
So
yes,
that is
Milord,
why the interim order
Milord,
was.
I have followed that case, Milord. What has happened in that case, some of the person of the same area has been allotted with patta. But those petitioner has been proposed or apprehending evictions, they were not the patta, Milord. That's why they were before.
No,
my
the
lord.
ones some of the persons are given patta,
My lord.
it means that it is not a forest land.
My lord.
It may be khas land. That will be treated
is
in a
correct.
different manner. Once it is forest land, the consideration will be entirely different.
Then the revenue regulation will come.
Yes.
This rule 18 will
Here
come.
18, there is no question of 18, forest land. Yes or no?
My lord, if the demolition is required to be carried out, then the pan India guideline is also applicable. My lord.
Where is the Pan India guideline?
My lord, maybe please, yes, my lord.
Have you annexed the relevant
No, my lord, it is a
page?
big judgment, that's
No,
why.
you could have annexed the relevant page.
Big one, my lord.
Which paragraph?
Yes, my lord, para 19, my lord.
Please give the name.
Lord, this is of in WPC 295 of 2022. And wherein, my lord, this guideline is also not applicable, it has also been clarified. My lord may be pleased to find, my lord.
This is by the Honorable Chief Justice as he was
Yes,
then.
yes, yes, my lord, Honorable the Chief Justice, my
Present
lord, para
Chief Justice.
89. My lord, paragraph 91 is very clear that wherein this guideline is not applicable, that has also been clarified, my lord. Will not be applicable if there is an unauthorized structure in a public place such as road, street, footpath, abutting railway line or any river body or water bodies, and also to cases where there is an order of demolition made by a court of law. Now, this is the detailed procedure of the notice, personnel hearing, final order, my lord. A detailed guideline had been given for the purpose of demolition and eviction, my lord. 7 days time is very limited, my lord. So that's why, my lord.
Heard.
In the recent case, Lordship, in fact, one case went to the Supreme Court on the contempt 3 days ago. In the hearing, the Honorable Court says a bench of CJI B.R. Gavai and Justice K. Vinod Chandran asked Hegre whether the land on which the families are residing belonging to the government. The Honorable Court said, if it is a government land, our November 13 order will not be applicable. Removal of encroachment from government land, land abutting water bodies, pavement roads does not require adherence to the SOP. The Honorable Supreme Court 3 days ago said.
Lord, in fact, that petition has been filed by
Yes,
my lord.
that's why he will not dispute.
My lord, this was the, my lord, just a verbal argument, but the guideline which we have relied on, this is the guideline, and for the violation, the Honorable Chief Secretary as well as the other person has also been facing contempt notice.
No, contempt is okay. We'll give the reply.
No, the notice has been issued. I
Notice
always
does
said
not
that
indicate
notice has been
anything.
issued. And their personal appearance has also been dispensed with. My lord. It has not directed. But personal
Heard 3 year, we have done it counsel for the petitioners. We are not disposing of this matter.
Lord.
We are issuing notice
My lord.
and we'll grant you protection of 7 days.
Sir, minimum 15 days.
No, 7 more days.
7 plus
More
7.
days, yes, to vacate on your own. Thereafter,
Lordship.
it will be up to the
Lordship.
Heard 3 year, we have learned counsel for the petitioners. Also heard 3 D. Sekya, the learned AG, assisted by Sri D. Nath, the senior government advocate. You are appearing for Forest Department or what?
Instruction. Right.
Okay. 3 P.N. Goswami, learned AAG.
4 and 5.
AAG is present for the Forest Department. Are we required to have your thing? Not at this moment.
My lord.
Are we required to put your instructions in writing in this order? Is it required now?
My instruction is clear, madam. The land he is claiming is
Forest.
absolutely forest land.
Okay.
And second matter, the judgment of the Honorable Supreme Court was in the context of my lord accused demolition of property of accused criminals. It has no connection whatsoever with government land and forest.
Okay. The petitioners who are, please have your seat, who are 59 in numbers, have put to challenge certain notices dated 24/7/2025, whereby they have been directed to vacate their land within 7 days. The challenge is, the edifice of the challenge is non-adherence to section 18 within bracket 2 of the Assam Land and Revenue Regulation 1886, violation of the Assam Land Policy 2019, and the guidelines of the Honorable Supreme Court in in its order dated 13/11/2024 passed in WPC 295 of 2022. Full stop. Para. Sri Bhuya, the learned council has contended that the land in question is under their possession since their forefathers
My lord.
and they are residing there. Full stop.
And also not a forest land. my lord.
Will not say that.
Or statement.
He has also submitted that though the notices claim the land to be forest land, till now there is no specific demarcation
My lord.
as to whether the land in question is revenue land or forest land. Full stop. He accordingly submits that in absence of any such clear demarcation, the impugned action would not be sustainable in law. Full stop. Para. Issue notice returnable by 6 weeks. 3. D. Nath, learned Senegal advocate assisting the learned AG, accept notice on behalf of respondent 1. 3. Revenue will take, I think. 1, 3.
Accept 4 and 5. Rest.
Except 2, 4, and 5.
2, 4 and 5. Got it.
Except 2, 4, and 2, 4, and 5. Mr. Goswami. Okay. Let extra copies be served within 2 working days. Para. 3. Bhuya prays for an interim order.
My lord.
He has submitted that the guidelines of the Honorable Supreme Court itself has envisaged a minimum period of 15 days.
15 days.
And 7 days period is too less. Full stop. He has submitted that the residential houses along with other
Permanent.
articles are
Fine.
are in the land in question, and without taking without taking into consideration the aforesaid aspects, the impugned order has been passed. Full stop. Para. On the other hand, Sri Sakya, the learned AG, has submitted that the land in question is a forest land, and even there is no requirement in law to grant time, as residing in a forest land is itself an offense, punishable offense. Full stop. He has also submitted that most of the petitioners have land elsewhere and are unauthorizedly and illegally occupying forest land, causing
And they are having possession of large chunk of land
having lands elsewhere.
in the reserve forest, occupying large chunk of land.
Causing environmental hazards. Full stop. Para. Sri Goswami, the learned AAG, has also endorsed the said submission and has reiterated that the land in question is forest land and the action taken is in the larger interest of the public. Full stop. Para.
And the order guideline of the Honorable Supreme Court in the.
He has also submitted that the guidelines of the Honorable Supreme Court, which has been relied upon by the petitioners, will have no application,
Since it is-
as those were passed in the context of certain persons,
Houses of accused
context of certain houses of persons who were accused
in criminal offense.
of criminal offense. Para. After considering the rival submission, this court directs that that the time to vacate be extended till 24 it was,
7th of August.
To 7th of August. And till such time, no forceful eviction be carried out.
Lordship,
However, after the said date, comma, the state will be within its bound to take take any steps for eviction and conservation of the forest.
one observation that Lordship has granted this 7 days time on the assurance given by them that they will vacate. Yes, that is the why I am not arguing, Lordship. They have given that, and Lordship has also taken
Recorded. The 7 days time is less, some more.
less. And this is in respect of the writ petitioners only. That may be clear.
The present order, however, will be confined only to the present petition and will not apply to any other cases.
Mal. Obliged. Highly obliged. But second one is also same, my lord. Only 14 petitioners are there.
Same.
Same.
Forest.
Forest is a
Same
different
land.
forest.
Area is different, my lord. I have
In
mentioned.
fact, Lordship, in there are 3 areas included. One is Gela, Gelajan, one is
In Golaghat.
Vidyapur, and the third one is Rajapukuri.
Rajapukuri. My lord,
So
there-
far as Vidyapur is concerned, already 100 houses are demolished today.
my lord,
But in Golaghat.
Golaghat, so in the nearby area.
Same. Till 7th.
Only one thing. In this case, there are 2 notices are under challenge. Notice dated 21/7 and 24/7. Earlier case, it was only
24/7.
21/7, where entire eviction has been done. So in respect to the petitioners who have served the 21/7 notice, they have been evicted, madam. today.
my
So this
instruction is
benefit,
that
earlier order
still the,
benefit
my
will
lord,
be
just
available
now,
only for 24/7 notice.
my lord,
3
just
days will not make much of a difference. If somebody is there till 7th, he is given time.
So one
Not
may
make
be
much of a
Lordship.
notice.
So it will be one, it will be 5th. The others one, it will be
Let it be 7th.
all 7,
Yes.
standard.
there is nothing. My lord, my lord.
Yes.
Highly obliged, my lord. Highly obliged.
Give them extra copies.
My lord, I'll start.
Returnable 6 weeks. Lord.
Yes.
Deeply obliged.
Specific. The respondents are the same, Mr. Bhuya.
My lord, same response.
So the door is open for him now.
To the
It is
TV,
only the
to-
petitioners.
to the TV channel.
No, the TV channel is open.
No, my lord.
This
We have heard
Facebook
that
is
you
also
come out
open.
TV very often nowadays. We have not seen.
And this video things will also be in the public domain.
No, it will not go.
We haven't had the privilege to, we don't have the time
Sometimes
to.
in talk shows, my lord, the invitation is there.
Not sometimes,
Sometimes.
every time.
He has overtaken all the earlier predecessors. The stalwarts he has overtaken.
Well, after my recovery from illness, my lord, sometimes some other works I do, my lord. Still I am recovering.
You might get a chance in Bollywood.
No, that much expectation is not there, sir. Only survival is, I am okay, my lord. Because I've just come out from such a situation, my lord, Almighty is there, my lord. That I am thinking, my lord.
That's positive. That's
Why not?
positive. We have not seen, but we have heard a lot.
My lord,
We'll try to also witness one day.
my lord, my lord. Obliged, my lord. Highly obliged.
Deeply obliged.
40? Fourteen, 15. Fourteen, 15. 14 to 14 to the which is it? 49 and 49 or 50. Yes.
Can be taken on any other day.
Okay, we'll have it some other day.
Two petitions are linked.
Oh, 49 and 15. On request list after a week.
Hearing them also.
After a week. we'll-
Fifth or so, my lord, fifth or.
We'll give a date, he'll give a date. Next, it has next Thursday.
It is a Louisville.
51. Mazumdar? What is this?
Lordship, this matter is that A cooperative society which is not registered as a wholesale cooperative society.
Cooperation department, who's there, cooperation department? Who? Dinath, okay, let him come. Why is senior counsel waiting? Mr. Tiwari is waiting for long and Mr. Das is also there. Mazumdar, Tiwari is from early from the morning. Which matter? Hearing matters. Hearing today, there is no scope.
39. Hearing.
Hearing will not be possible. It was a very slow track today.
My lord, we have seen, we have.
Very slow
My
track.
lord. Good that we still see some smiling, but otherwise it was very active.
We have to make the track a bit faster. Something has gone wrong today.
Lordship may fix any other day.
We'll have a date. Mr. Tiwari, which matter?
Item 40.
Hearing.
Yes.
Hearing, to it will not be.
My lord, I understand. My lord, could it be, my lord,
40 is what matter? Which year?
2015?
Oh. So sorry,
My lord,
15
actually,
matter.
the
We
date
do
of
not.
the petitioner.
Even Mr. Kejriwal's matter is very old.
Yes.
That we have heard for some time also.
And my lord, in my case, apart from the year of the case, there is another factor also which is pressurizing me a great deal. The name of the petitioner. So that is why it is Nabam Tapin is already dead.
Okay.
Nabam Tapin is replaced by another person. So that is giving me additional pressure.
Who?
It happens to be RH Nabam. So,
Okay.
so my lord, could it be, my lord, any time, my lord, August?
We'll
24th?
give you an early date. But
My lord, because next week.
next week will be slightly, because after 11th, I think we may have some breathing space. 10th, as you know, because of this program.
Then I'll be in the Itanagar also, my lord.
10th, you know, 10th, because of 10th, we are
So,
just,
my lord, could it be from 24th August onwards, any day?
we can give a date, 24th.
26th of August. 26th.
26th August. On request, item number 40. On request.
26th.
The 13-9, Lordship will kindly fix it on 14th, my lord, the hearing day. 14th.
Your that land acquisition matter.
Yes, my lord. Your Lordship heard the matter. At
Yes,
some
yes, yes.
length.
Then we released from Pathat again, it came back to us. We don't mind taking if it's on roster.
14th.
Have you chalked out anything?
I already.
No, but Mr. Kejriwal said that if he is willing to leave something, but provided he's paid a fair amount, he may not go back to the entire legality of the acquisition proceeding.
Yes, that's what I say. If it is a matter of enhancement of compensation.
Yes.
And calculation under the 2013 Act.
Yes.
Then possibly either it goes to the
So
collector.
that part we have considered.
My lord.
I think limitation around 226 we can make it goes as a direction. He'll not be barred by limitation.
No, I'm not saying that. What
No,
I'm
that apprehension he was raising.
yes. Lordship, there is
No, there will be a statute, but we are this matter is before us since 2013.
13 years,
Yes.
below.
So that
And
part
even your lordship may kindly see, there are latest judgments of the Honorable Supreme Court that if there is a violation of section 5 and 9, in that case, the entire proceeding will go. Even the award is to be.
no, that we may not be. We may have difficulty in view of the development.
Yeah.
We have to balance the equities.
Milord, the awards have been passed during the pendency, Milord.
We know, but we have
Without
asked
giving
you.
any
You have
opportunity.
asked you. Will you be satisfied with a fair compensation? You have said yes.
And they have accepted the compensation, entire amount of compensation.
Okay, this will be on
14th, man.
14th. Yes.
39. 14th. My lord.
Yes.
39 and 43 also.
43 is what matter.
That matter, your lordship, the TD is missing.
Or that
Yes.
Silpukuri case.
Yes. Let it go.
What is the stage of that case? Now something has been retrieved, I think, reconstructed.
What has happened? In the meantime, two documents have come. One, an affidavit from the government, enclosing a report. They made an inquiry. as regards this, and the other document is the order sheet of the lower court records. From that, it appears that the CD has gone missing. It went missing something in 89. But whether any steps were taken any.
Okay, we have a date.
Yes.
Don't put in the same date. Your casuals matter will take some time.
Yes.
Have it on some other day.
Then let this be on 11th. Oh, 11th August. Okay. I'm just checking.
He'll give a date. He'll give a date. He suggests a date, he'll give. As agreed to by the land council for the parties. Huh? Take it. Mr. Das, which matter?
12.
Which one?
12.
Hearing.
No, it's an addition, supplement.
Part had matters, Lordship. It had
Part
been
heard.
heard by a coordinate bench and it was fixed, substantially heard. It was fixed for further hearing, Lordship.
Item
Order dated
number?
Item 55 and 56, Lordship. Order dated 15/7/25 will be relevant, Lordship.
We don't mind if you, both of you agree upon.
Might be
If
listed
it's heard
before the
substantively,
appropriate
then.
bench, Lordship.
Mr. Das, what do you say?
I don't mind wherever it is listed. I can argue here also. There is no problem.
We have to write
Well,
earlier.
for me, there is no problem. I can argue the matter here also.
Since it has
For
been
me, no.
No,
I'm
if,
just saying what you
if
say.
what your colleague is saying is correct, then if you're endorsing, then we can send it back.
Lordship, might be listed before the appropriate.
Which is, who heard the matter? Which court?
Justice Arun Dev Chaudhary. He's in the division bench actually.
Whenever available, the bench will be.
When was it heard?
It was heard on 15/7 as well as on 18/7.
Oh, recently.
These are recent.
Okay, you are Saraf,
Only it is not reflected somewhere a part of it.
No, it is reflected in order dated 15/7, Lordship.
Further hearing, it's further.
Substantially heard.
Heard Sri D. Saraf, learned counsel for the petitioner, as well as Sri D. Das, learned senior counsel for the
PF, my lord.
PF.
Author.
1, 2, 3. Full stop. Both the learned counsel have submitted that the matter has been substantially heard by a coordinate bench on 2 dates. Full stop para. In view of the said submission, raised you to verify and place this case
My lord,
before
my
the appropriate
standing
bench.
counsel is Mr. Joyraj.
Assisted by Sri J. Bora.
And Mr. Fukan appears for the receiver.
Receiver. R5.
RB Fukan for R5. Huh?
There's
Okay.
an interim order, Lordship.
Interim order passed earlier to continue till the next date of listing.
Obliged, Lordship.
My lord, I have a prayer, my lord. Item 50 to 53, there is an interim order.
We'll extend the interim order.
It
This
is
is how, what matter?
Hearing,
Interim order Interim order Mr. Burua, just inform our court master.
Hearing matter, item number 44.
Yes.
Date,
We'll have a date. Matter of which year?
2 September or
No, which year? Matter of which year?
15.
15.
Complementary.
15 matter will give an early date, don't worry. And Mr. Khandulia, this matter, court cannot take up your matters. Those,
Otherwise, at that time, activity, your lordship was representing,
but this same matter, I think.
not the same matter.
NCLT.
Not the same matter, but there also Dolu was involved otherwise.
No, we'll not take it up. We have just seen the name. Which are the numbers?
44.
44 item.
44. 44, huh? This is before any other bench without me. This Bura brothers was there even in that case.
No. It was between the shareholders. Buddha Brothers is, here the company petitioner is filing this application for.
Oh, no, Dulu, I think we are connected. This is before any other bench. Okay, rest of the matters, if there is urgency, dates will be given, otherwise it will be listed. Okay, next step.
Any other?